This conference will now be recorded.
एक्चुअली जो वेडनेसडे का मेल आया है उसमें 10 ही है, 9 का नहीं है.
Okay, anyway, let us move forward. Recording is started. Yeah, I request Aditya ji to start the session.
Yeah. So welcome everyone, and today is the important session, and I'm really thankful that CA Atul Purani ji has accepted our invitation, and obviously Dilip sir will introduce the speaker for today's session. And literally I want to thank Dilip sir also. He's been very much in touch with the speaker and really took forward this session, wonderful session, and we have a altogether a different speaker. So here today we would like to hear from him the insights on the analysis of the recent judgment by Honorable Delhi High Court regarding suo moto proceedings, which we have seen will play an important role in future. And now RERA has been there are many changes, so this will obviously play an important role. So I'm really thankful to Atul sir for taking up this important topic and looking forward to his session for the entire topic, and it will definitely help all our study group members, and it will provide them inputs in future, and their perspective towards this judgment and the implications will obviously they will have a proper way for moving forward in this profession. Thank you very much.
Yeah.
Over to you, Dilip sir.
Yeah, thank you, Aditya ji. Well founded. You laid the foundation stone for the topic today, and yes, I am very proud and glad to introduce our own study group member, Sri Atul Purani ji. He is a very senior chartered accountant, as we all can see him, and he has been practicing as a chartered accountant since 1990. And he's very passionate while he's doing his work, and social activities, he's lots of things he's engaged. And main 2-3 things if I would like to share between you is he has been a continuous donor, blood donor, and motivating others also to donate blood. He's associated since 1980. You can think of, without before being chartered accountant, he have been associated himself for the social cause, and that blood in the Nanavati hospital since 1980, and that blood being used for the thalassemia patients. And last 2-3 years, I think Nanavati hospital has been taken over, and they have their own system. Right now might be because this is not a trustee, Nanavati's trust, therefore he is now no more associated, but his passion for so many years is very commendable. I would share one more thing. He is continuously supporting one of the Gurukul Kanya Vidyalaya kind of thing at Gujarat, near to Valsad, Dharampur, where he used to serve them to the trustees also free of cost for since beginning. And sometime he goes there as a faculty, and he is a mentor for the trustee to guide them what will be bringing the quality of the education and the service to the students in that Kanya Gurukul. And with these small things, only qualification everyone can see, he's a BCom, LLB, FCA, and he's hiding his identity most of the time because he's a true server, जो ईमानदारी से सेवा करने में लगे रहते, कभी भी नाम की परवाह नहीं करते. हमारे अतुल जी उनमें से एक है. तो हम आप सभी लोगों से रिक्वेस्ट करते हैं कि जोरदार तालियों से इनका स्वागत किया जाए, और हमारे बीच में आज अपना एक्सपीरियंस एक नए टॉपिक पर, जो कि हम नॉर्मली नहीं सुनते हैं, सुओ मोटो क्या है, किस प्रकार से अथॉरिटी अपने सुओ मोटो पावर्स को यूज कर सकते हैं और कहाँ यूज कर सकते हैं, ये सारी चीजों का भेद आज आपके सामने में इस स्टडी ग्रुप में खुलने वाला है. थैंक यू, एंड आई एम हैंडिंग ओवर टू अतुल भाई एंड बिफोर दैट जोरदार तालियों से इनका स्वागत मैं चाहूंगा सब लोग मिलकर करें. Over to you, Atul bhai.
Thank you for such a kind word. And this social work was a passion before the I started practicing. So that passion is still there, but now age and people are taking over. We are, as you rightly said, mentoring is creating a second generation to take over. And rightly in that direction, many educational institutes and all these places, it is nice to see youngsters taking over and with passion also, which is a rare thing. About this topic, I think one of the
Sir,
member,
one thing. Sir, 1 minute
Ji,
I will take again. Sorry to
yeah,
interrupt.
not a issue.
I forgot to share, say last week when I talked to Atul bhai, you may not believe his whole family was COVID infected. He was dealing with the health issues of his family members along with his own health issue. And he said, can we postpone today's this session to some other day? And believe me, he is kind enough that such a mentor, I could mentor him, and he could accept my request to handle in the given situation to maintain his promise and word which he has given to the bigger, larger platform. In the interest of everyone, he prepared during these health issues and prepared the PPT, completed all the things, and now he is with us. Great, great, Atul bhai.
Thank you, sir. It was you who was a tough master, absolutely tough master. Task you said, you motivated me, and it has been given, Atul bhai, everybody is informed. So up to Saturday I was in home isolation anyway. We are all passionate about this group also. uh, this topic, I think one of the member, when it was judgment was pronounced on 28th of May, Rashmi, I think one of our member, I don't see her here. She's just one liner. She suggested that can we discuss this. Aditya had shared this judgment, and I was fascinated. I'm always fascinated by some of the judgments who is logic too difficult to understand or digest such judgment. That how come this thing, you have you are the authority, you have powers, but the powers were uh, overused, and absolutely we were all thrilled to see the judgment, and we thought that okay, the great thing, the Delhi RERA has tribunal has given a absolutely great judgment and it will have an impact on the entire India. But no, sir, very sorry to say, this judgment was totally quashed and reversed by Honorable Delhi High Court on a very clear understanding. If we read the judgment, they were justified in returning, but maybe the tribunal overstepped, like the previous judgment we had on a single member tribunal. All the judgments were held wide, and for the first 2 3 years we were all thrilled. Okay, हमने तो client को खुशी कर दिया, stakeholder home buyer को. Later on L&T hired a big lawyer, and it got reversed that look, you have no power. So similarly, this was very quickly. Of course, that time it took 2 3 years. This is I think November 21 judgment of tribunal, and got reversed in May 22. Uh, we are talking about. I had made a executive summary. How will we go through this? Where we are talking about one line on a judgment of DRAT, which was already there in 2018. Then who has suo moto power? What is suo moto? Role of real estate appeal tribunal under RERA, because to arrive at a conclusion we must go through the whole process. Understanding suo moto power of RERA, original jurisdiction of the Delhi High Court. Then our Maharera, I have just covered the slide. They are also same inherent, because we belong to WIRC, so I had included this point also. Then power of appellate code, that is Code of Civil Procedure 1908. This is a appellate tribunal is a civil procedure code. It is not a criminal procedure code. No, criminal procedure will not apply. And there were certain writ petitions were filed, very famous Swapnil promoters and Neil Kamal, where High Court merged all the writ petition, and they said that look, uh, it is constitutional, RERA is constitutional, all chapters are constitutional, and it is valid and in effect. And then lastly, we'll go to the this particular judgment of Praveen Chawla versus Real Estate Appellate Tribunal, and pronounced by Delhi High Court. In somewhere now this is we are discussing this about 2022, while in 2018 that recovery appellate tribunal had given a judgment, and which was reversed by the same Delhi High Court, that DRAT has no inherent power to take suo motu cognizance in the public interest. Mind you, public interest litigation, then also you have no powers. This is Padam Singhi versus SVOGL, Oil, Gas and Energy Limited, and which is very widely I have included into the main judgment. Last slide. Now we go to the next slide, where we are talking about suo motu contempt power is inherent. That is, Supreme Court had mentioned again and again that these powers are available only to High Court and Supreme Court, not available to any junior authority, judicial or otherwise. So no requirement for taking consent of anybody, including the Attorney General, because of the court is exercising its inherent powers to issue notice of contempt. This was a judgment based on a advocate Prashant Bhushan's tweet, where the lawyer was found guilty of contempt. As far as the suo motu petitions are concerned, there is no requirement for taking consent of anybody, including the Attorney General, because the court is exercising its inherent powers. Mind you, inherent powers. But the suo motu powers are not inherent in for the tribunal. Some of the powers are given in RERA for the RERA authority to take suo motu proceedings, but they don't have this particular power. So we'll discuss it at length later on. There is inherent power to issue notice for contempt. It is equally well settled that once the court takes cognizance, the matter is purely between the court and the contempt law. It said the only requirement is the procedure to be followed is just and fair in accordance with the principal nature of justice. Suo motu is a legal term having its origin in Latin, which simply means on its own accord. When a case or a matter is taken over by the High Court or the Supreme Court under its control and initiate proceedings against the same, it is known as suo motu action. In various instances, the legal proceedings were initiated by the courts on their own. And based on telegrams, media reports, letters, anything. The principle behind this is to provide justice to everyone, and even to the people who would not be in a position to afford it. Here and the previous slide also, social justice, justice in fairness, but if you see the judgment reversal, it is not in the interest of the public at all. That if there is anything that breaches the fundamental rights of the people at large, then the court would take action against the same by exercising its suo motu power. Now, this article expounds on the concept of suo motu cognizance power of the Indian courts and the evolution of this concept in India. It further discusses the constitutional provision that deal with this subject, and also sheds lights upon a few case laws which were taken up by both the Supreme Court and the High Courts by making use of their suo motu power. Some of these slides will then we may go faster also, if you are not we are not keen on what is suo motu cognizance, sir. Dilip sir or Aditya. Okay. Now PIL, it started, suo motu started with in the High Court as a PIL, where Justice Bhagwati said that concept of PIL is a person or a group of person who has suffered from any legal wrong or legal injury, but the person or the group person by the reason of poverty, helplessness or economical disadvantage is not able to approach the court. Then a member of public can file an application on the same on their behalf, and under the Article 226 in the High Court, and under Article 32 in the of the Constitution for the Supreme Court. This concept operates in an effective way in democratic country like India, as it acts as a powerful tool in changing society and also its social welfare. It gives a vast interpretation of the right to quality, right to liberty, and the right to life, which are fundamental rights enshrined under Part 3 of the Constitution. How it evolved. Over a period, the stretch of India jurisdiction has also been enlarged. The court is now including letter petitions also, took suo moto cognizance of the aggrieved parties whose fundamental rights were infringed in the realization of their role as only protectors of individual fundamental rights. One of the first recognized letter was a Sunil Batra's petition. He was a prisoner who wrote a letter to one of the judge complaining about a brutal assault on his co-prisoner. The letter was brought into the notice of Supreme Court, where the apex court considered it as a PIL and took suo moto cognizance. And in the same case, the Supreme Court issued guidelines which are to be followed by the jails for the administration of prison justice. We are discussing it because this is suo moto power which was exercised by RERA Tribunal. Now, courts exercising suo moto power, there is order pro for a new case, or court on its own motion can also take cognizance and start. This slide I am going faster because it is just a suo moto for the general in general. It can reopen old cases. So all types of, if you see my citation, the banks are involved, individuals are, prison is involved, almost all agencies. Contempt of court is also included into this. In very famous case of Arundhati Roy, where in the initial stage when we were taking pride that Amartya Sen, Nobel laureate, is of Indian origin, she made certain articles and she said, no, why you Indians are going mad about it? He doesn't belong to you. He left you. He deserted you many years back. How can you say he's an Indian? So then she wrote a article, "The Greater Common Good" in Outlook magazine, and where her comments on Indian judiciary, which were prima facie a misrepresentation of the court, and she was liable for a proceeding against the contempt of court. So, Constitution gives powers to the Supreme Court and the High Courts. Repeatedly, I am saying that to take suo moto action when there is a contempt of court under Article 129 and 215 respectively. Article 129 Supreme Court, Article 215 High Court. In the case of breach of violation of fundamental rights, a PIL can be filed in the Supreme Court, and accordingly, the requirement the courts may take up cases into their own hands and act. So, in the case of fundamental rights, Supreme Court and the High Court may take suo moto action against these articles, Article 32 and Article 226. So, the conclusion of suo moto cognizance is the concept of suo moto cognizance has democratized the judicial process in India. This has become another way to enforce the fundamental rights of the people effectively and efficiently. The courts in India, after the introduction of the concept of suo moto cognizance, have made sure that the state governments and the central government are monitored properly and justice is not denied to the aggrieved person merely due to his economic and social conditions. Here, Appellate Tribunal said entire Delhi, because entire Delhi in NCLT means it is like MMRDA, हमारा यहाँ पे पनवेल, Kalyan, Bhiwandi, everything is included. So many people, nobody had power or even access to judiciary. This facilitated public participation in the judicial process and also enlarges the scope of Part 3 of the Constitution. Now, we would understand role of real estate appellate tribunal under RERA. So, how under what this is established? The powers are summoning and enforcing the attendance of any person and examining of an oath, requiring the discovery and production of documents, receiving evidence on affidavits, issuing commission for examination of witness or documents, dismissing an application for default or deciding, directing in ex parte, any other method which may be prescribed. And this is not under prescription at all. All proceedings before the appellate tribunal to be a judicial proceeding under the IPC and shall be deemed to be a civil court. I said in the beginning that for the purpose of section 194 of CPC 1973, the appellate tribunal shall not be bound by the technicalities of the Code of Civil Procedure and the Evidence Act. Many a times we have seen that like Evidence Act is very thoroughly followed by the High Court, but not by the appellate tribunal. We all are expert in appearing in MCA or GST or even income tax tribunal, where evidence is not the way evidence is understood under the High Court or Supreme Court proceedings when it is Evidence Act is applied. Here in RERA, I think one of the meeting, the then chairman said that हाँ कैश की भी रिसिट लेके आओ ना हमें क्या फर्क पड़ता है आपने बिल्डर को कैश दिया है we will accept it. So additional tribunal shall be bound by the principle of natural justice, and additional powers are require the promoter or allottee or real estate agent to furnish in writing such information or explanation or produce such documents reasonable time as may deemed necessary. Requisitioning any public record or document or copy of such record or document from any office. Now, role is this to it may call upon such experts or consultants from the fields of economics, commerce, accountancy, real estate, competition, construction, architecture, engineering, any other discipline as it may deem necessary to assist the appellate tribunal in the conduct of any inquiry or proceedings before it. Every order of the appellate tribunal under this act shall be executable by the appellate tribunal as a decree of the civil court, and the appellate tribunal may send any of its order to a civil court having local jurisdiction, and such civil court shall execute the order as it were a decree made by the court. This is as far as the powers and how RERA tribunal were formed and what powers they had. Because to understand this decision, we have to understand the powers given to the tribunal also. The suo moto powers of RERA have been enlisted under sections 7, 35 and 38 of the Act. The RERA can take action on its own accord in matters pertaining to revocation of registration, calls for information, or conducting investigation. They can also suo moto refer the matters that has effect on the market power of monopoly to the Competition Commission of India. However, the appellate tribunal has not been conferred with any suo moto powers. This is very uh, legislation is not silent on this. It was very clear when this was drafted that you have suo moto powers for certain things, but your appellate tribunal will not have power to any suo moto power. We'll discuss this at length when we come to that particular judgment when it is very clearly established. Suo moto powers are under section 7. It says the act authorizes the authority to cancel the registration granted under section 5 in 3 conditions. One, in response to a complaint; second, in response to a competent authority recommendation; and third, even suo moto. It merely needs to record its satisfaction that a promoter failed to perform anything needed by or under the act or the rules or regulations issued thereunder, or that a promoter breached the terms and conditions of the permission granted by the competent authority. Now we'll discuss the next section, suo moto powers of RERA under section 35 of the Act, because this was very misleading that we had powers for the tribunal. Suo moto powers were there in the RERA. This section deals with the power of RERA to call for information and conduct investigation into allegations against a promoter, allottee, or agent. The RERA has been conferred with the powers of a civil court as vested by the Code of Civil Procedure 1908 with respect to the discovery and production of books, summoning and enforcing the attendance of person, and examining them under oath and issuing commission for the examination of the witnesses. Books are beneficial in order to ascertain if the developer is using the finance provided to him fairly, since he is duty bound by law to use the money contributed by the home buyers toward a specific project to be used exclusively for the project toward which it was contributed. An examination of these books can reveal any financial irregularity in the developer accounts for which he can be held liable. Now, if they do not comply with the orders to produce this document, RERA can appoint a commissioner to search for such books. Examination of witness under oath is crucial to ensure that the documents exchanged between the developer and home buyers are real and verifiable. The RERA can also choose to conduct an oral examination of a witness and may administer oath for the same. Section 35(2) Clause 3 of RERA authorizes the regulator to issue commissions for the examination of witnesses or documents, much like a civil court. This would allow the regulator to investigate all aspects of developers or uh, litigants' complaint. Suo moto powers of RERA under Section 38. In the event that any of the acts of the promoters or allotee may potentially have the effect of monopoly in the real estate market, then the RERA has the power to suo moto refer such matter to the Competition Commission of India. But that is all they had the power. The Real Estate Tribunal. Now we are going to discuss it. Does it really have the suo moto powers? The tribunal. The tribunal was established to hear appeals against the authority rulings. Section 43 of the Real Estate Act says that Real Estate Appellate Tribunal can assess the constitutionality of RERA orders and decide whether to sustain or overrun them. REAT orders can be appealed to the High Court. Though the Karnataka RERA came close to the acquiring judicial power, all the states' RERA are quasi-judicial bodies. Currently, none of the RERA tribunals have suo moto powers to initiate proceedings of any kind. The Delhi High Court in Praveen Chawla, which we are going to discuss, has held that the Appellate Tribunal is a body whose origin and form exists because of the provisions of the Act. Its adjudicating authority comes from a special statute, and this body is not a part of the hierarchy traditional judicial institution of India. When I started researching and researching, it is very mind blowing. You know what our normal concepts got clear. The Supreme Court, in the case of Messrs. Takimont Private Limited versus State of Punjab, has held that the appellate authority cannot waive the limitation or precondition prescribed by the statute for filing an appeal on its own. The inherent incidental or implied powers vested in the appellate authority cannot be invoked to render a statutory provision nugatory or meaningless. Now, Central Advisory Council was to be formed by RERA. The Act provides that you can have a Central Advisory Council, which is required to advise the central government, because we have the state-wise RERA. There is a Central Act and then there are state-wise. On matters regarding policies concerning the Act as well as how to promote the growth of the real estate. So recently we saw that during COVID pandemic, the ministry issued this necessary advisory to all states, union territories, and other regulatory authorities in May 20 to address the concerns of the home buyer who have interested their lifetime savings and to ensure the completion of project based on the recommendation of the Central Advisory Council. The authorities of almost all state and union territory were permitted, and they issued notification also to invoke the force majeure clause and suo moto extended the date for the completion of various projects. Some of these state even gave 3 extension of 6 months each. Now we'll go that who has the power. Whether I was checking whether my tribunal suo moto judgment is quashed, whether the Delhi High Court had the powers to do so. So I saw that there are 3 jurisdictions of the High Court. Delhi High Court was formed, the Act very recently, 1973. It is prior to that it was formed, but amended and new Act was formulated. It refers to the original jurisdiction. what it means, authority to take cognizance of the cases which can be adjudicated by the court at the first instance. In the appellate jurisdiction, court has the power to rehear a case already heard by a lower court. However, in the original jurisdiction, that particular court is approached first with respect to the matter specified. It also includes writ jurisdiction. Then the next comes as supervisory. Sorry. Supervisory jurisdiction. Under Article 227 of the Indian Constitution, the High Courts have been provided the powers of superintendence over all the subordinate courts and tribunals within its territorial jurisdiction. This power of the High Court does not extend to the Armed Force Tribunal. We have executive arm separately, and it is good to have that democratic process, judiciary separately, parliamentary separate. This enables wide powers to the High Court to interfere in lower courts proceedings to prevent grave miscarriage of justice. The powers of superintendent is different from the appellate jurisdiction. The power under Article 227 can not be controlled by a statute and can even be exercised when the tribunal power is declared to be final and conclusive. So it is a superior court. Then I have covered this that same powers about in chapter 19 of notification of RERA, which says about inherent powers of the tribunal. Uh, I may skip this because this is all repeating. That it shall deem to be limit in a powers of tribunal to make such order as may be necessary for meeting the ends of justice or prevent the abuse of the process of the tribunal. Nothing in this regulation shall bar the tribunal in conformity with the provision of the Act, and then nothing in this shall bar the tribunal to deal with any matter which no regulation has been formed. If they feel in a function in a matter it thinks fit. Then the eighth point of this presentation is power of appellate code of civil procedure 1900, because we are talking about that it is falling under civil procedure code. So what are powers under that? Because you have a power under a particular statute RERA, but you have a parent body like code of civil procedure 1908 under which you may follow. So mostly the power of appellate tribunal, almost all powers, all appellate tribunal is subject to such condition and limitation as may be prescribed. The appellate court shall have power to determine a case finally, to remand a case, to frame issues and refer them for a trial, to take additional evidence or to require such evidence to be taken, and subject as of aforesaid, the appellate court shall have the same powers and shall perform as nearly as may be the same duties as are conferred and imposed by this code on courts of original jurisdiction in respect of suits instituted therein. Then I have covered writ petition of 2017, certain 2-3 paragraphs of those judgments, where of Sapnil promoter and Neil Kemal, which most of the members are aware, where it was that provisions of RERA, these sections, it doesn't cover anywhere the powers, suo moto powers. That it said that it cannot be said violative of Article 14, 19, 20 into bracket 1 and 300. So those 32, 225, 229 is not covered at all here. Then that next paragraph said that the judge said that my learned brother has dealt with this aspect and I entirely agree. So it is a 100% judgment. It is not there was a varying judgment by a different member of the same bench. No? We place on record our appreciation there. The in matter also, sorry. Friend of the court, amicus curiae was appointed, and they helped the judge to arrive at a conclusion. We hold that the challenge to constitutional validity of proviso 3 to A explanation to provision 3, 4, 4, and 5, and the first provision to section 6, 7, 8, 18, and 20 right up to 63, but it is not covering anywhere inherent powers of the suo moto power. Fails. So these provisions are held to be constitution valid and legal. This matter was not never taken up by in those writ petitions. However, one of the qualification for appointment of a judicial member, which I said that you have to have one member, single member, this was struck down. That prescribed in section 46 1B or has been a member of the Indian Legal Service and has held that post of additional secretary of that service or any equivalent to it is severed and struck down. There were two different judgments on that. That single member cannot have a then the entire judgment was void ab initio, or if you had a judicial member you should be qualified to be a judicial member. In this writ that was also removed, and we hold that two major member of the bench shall consist. Then they issued a guideline that one should be a judicial member and the other could be any member. And there were some errors where after the judgment was drawn, the learned counsel went for a correction, and court said no, we will not make any accept your request on the correction now when the judgment is already pronounced. Now this is what we are going to be discussing main thing. Some of these slides already covered were uh, included in this very detailed judgment, were very beautifully dictated, and it will be clear as a takeaway in the end that whatever we talk about fairness, judicial thing, we overstep it. Means the tribunal overstepped its jurisdiction, and such a judgment where Delhiites or all over India, where everybody was happy that look, we have a RERA tribunal, they can take suo moto. मैं गरीब आदमी, they are bouncer. We do. I invested 1 crore or a 10 lakh or a 1 lakh. I could never find a developer. Now suddenly everybody had a hope that look, the tribunal has powers and we'll see the justice and all that. That was totally reversed and quashed. Now this is a 27-page judgment, but in the PowerPoint it went little longer. So we'll start with this. Uh, the facts of the case were there that the petitioner is a builder developer by profession, has instituted these proceedings seeking the following reliefs: issue a writ, order and direction, directing the respondent to place on record all the necessary records pertaining to case title suo moto case number so and so, court of its own nations versus commissioner of municipal zones. Mind you, this is, you will be shocked when you go by each paragraph of the judgment, where three or four highest authority of Delhi didn't bother to respond to tribunal. Commissioner of police, DDA, then municipal commissioner, even the lieutenant general, nobody bothered to proffer them requisite details in the time given to them. This is very shocking. If you don't respond to a tribunal and tribunal has no powers, how will we run the process? They, that is why High Court was shocked, almost stopped and restrained, and that is written in two-liner that it did not reprimand the tribunal that how this judgment you can pronounce. It said that because these authorities failed to respond to you within the time, that is why you took this decision of staying the entire Delhi. No commercial, no industrial, no residential construction at all. In terms of impunge order, the RERA tribunal has drawn suo moto proceeding in respect of various residential and commercial projects and construction activity being undertaken in connection here with the NCT, National Capital Territory, and as I said, to understand it better, in Mumbai, Kalyan, Bhiwandi, Panvel, Alibag, everything is concerned. Like this, almost 200-kilometer stretch of in and around Delhi is covered under NCT. and passed orders of restraint in terms of noted here and after. The orders of November, there were two orders, 17 November and 24 November, in terms of which proceedings were initiated, record as follows. This was the original order by the tribunal. It has been mentioned before us that there are large number of projects under construction falling within the jurisdiction of this tribunal. So it was falling under this jurisdiction of this tribunal, where the mandatory provision of the registration of project under the RERA has not been complied with. A number of projects have been mentioned at the bar. However, we deem it necessary to verify the details before we name the properties here. Section 3 in Chapter 11 of the Act provides for registration of a real estate project, stipulate that no promoter shall advertise, market, book, sale, or offer for sale, or invite person to purchase in any manner, any plot, apartment, or building, as the case may be, in any real estate project or part of it, including phase wise, in any planning area, without registering the real estate project with the RERA established under the Act. Subsection 2 relates to the Applicability Act, where the area of the land proposed to be developed exceeds 500 meters or there are less than 8 units, then also you are exempted. The registry of the tribunal also points out that they had addressed couple of communication to the Commissioner of Police seeking details of the FIR registered in respect of societies, individuals offering membership or housing project and fraudulenting collecting huge amounts of money from the gullible buyers within the jurisdiction of Delhi and especially in areas falling under the land pooling policy initiated by the DDA. The details are stated to have been not received till date despite lapse of considerable time and also a reminder. So shocking. And here it reminds me there are in our city also there are two beautiful judgments. People, our members can also take note of this. That Malad police station there was one judgment and there was one judgment about a chamber police station. We can search for it. Where if a investor or a agreed in the real estate market goes and to file the police complaint, they have to file it and make it as a FIR, not non-cognizance. It is not NC. It is your fundamental right, and police has to be take action, and SHO otherwise will be suspended. This is because of a High Court judgment, and they are scared because of the contempt of the court. So uh, anybody can walk in into police station and make a complaint with, of course, proofs and evidence. So, keeping in view the aforesaid background, it is considered and appropriate that suo proceedings are initiated in the matter to ensure that there is a strict compliance of the provisions of the Act and the gullible buyers very repeatedly this is mentioned, but ultimately left as gullible only. Gullible buyers are not left to be cheated by unscrupulous persons operating in the construction business. Accordingly, issue notice to the commissioner of all the municipal zones because there were many municipalities covered. The vice chairman of the DDA, the chairperson, the NDMC, New Delhi Municipal Corporation, as also the commissioner of police, Delhi, returnable on 24th November 2000. Time was given. In terms of order 20 of after a week, the appellate tribunal noticed that the RERA places an obligation on all developers and builders to ensure that projects are duly registered and completed in accordance with the provision made herein. The appellate tribunal has observed that the aforesaid order that the developers appear to have undertaken construction of project without complying with the mandatory obligation of registering the project with the RERA authority and thus violating the provisions of the Act. Upon record of the aforesaid conclusion, it proceeded to pass the following order. Accordingly, in view of the above, all construction activity in the NCT of Delhi, residential as well as commercial, falling within the scope of subsection 2 of section 3 of RERA being undertaken without registration with the RERA authority is stayed until the registration of their project with RERA. The concerned commissioner as well as executive engineer of each of the municipal corporation, DDA and NDMC, and also the commissioner of police through their concerned station house officer of the local police station of each area shall ensure that with immediate effect no such further construction activity falling within the scope of subsection 2 of section 3 of the act is continued in the absence of RERA registration. The concerned field staff shall undertake a survey of each of the properties under the construction in their jurisdiction and take necessary steps in terms of this order, take photographs as also the details of the developer. Now here I'll take a pause that now today FASTag and GST and all these toll nakas and surveillance has become so simple. Why taking a photograph? You can have an electronic surveillance, satellite surveillance also. People are caught in GST and without e-way bill and all. So, but here again, as I previously said, that Evidence Act is not strictly applicable to tribunal. Though maybe they say it, but otherwise, why photographs and all? You have electronic surveillance. Furthermore, it is directed at all municipal authorities granting sanction of plans in respect of properties falling within the scope of this act shall grant the sanction subject to their obtaining registration with the RERA. Each of the respondents shall file a status report with respect to the action taken by them in terms of this order within 2 weeks. 2 weeks, 5 महीने हो गए उसके बाद it got reversed, but nobody even acknowledged the summons or even proffered any response. Mr. Anil Kumar, ACP, look, ACP appeared, not when the Commissioner of Police was summoned, shall also file a comprehensive status report furnishing details of the FIR registered in respect of societies, individual offering membership of housing project and fraudulently collecting huge amounts of money from the innocent buyer within the jurisdiction of Delhi. They shall also coordinate with the RERA with respect to complaints received by them other than those FIRs as are already registered. We'll go to the next slide. The petitioner has approached this court aggrieved by the fact that he has been informed by the appropriate development authority that the plans as submitted cannot be accorded approval in the light of the orders passed by the Appellate Tribunal. When the writ petition was initially entertained, our learned judge of the court on 17 December 2021, very fast the judgment came, took note of the submission address at the behest of the petitioner who had contended that the appellate tribunal didn't have any jurisdiction to initiate suo moto proceedings. This first reading, that how? Suo moto powers are already there. When I also read it, I had that impression. Upon a consideration of the importance of the question which stood raised, the court appointed Mr. Rajiv Mehra, a learned senior advocate, as an amicus curiae and set down the matter for consideration of bearing in mind the jurisdictional challenge which was raised. Here again, I would take a pause and say amicus curiae is that person who is not a party to the case, but is the one who is voluntarily or upon the invitation of the court instructs and assists the court on a matter of law concerning which the letter is doubtful through filing of his briefs in the court against the matter to which he has been appointed as amicus curiae. This court on 21st March 2022, upon noticing the questions which had been formulated for consideration, deemed it expedient to join the authority as a party as a respondent. Pursuant to the direction issued by the court on that date, appropriate steps for service upon the authority have been taken. However, none appeared on this behalf. First, I was talking about other authorities, municipal authority and state authority, DDA authority, chairman. Here the RERA tribunal, nobody. That authority, nobody appeared. Next paragraph, we'll go to the erudite and learned amicus has addressed the following submission. Mr. Mehra submitted that the powers of the appellate tribunal stand duly enumerated in section 53. The learned amicus would contend that the act confers no power upon the appellate tribunal to draw proceedings on its own motion. Learned Abacus has also taken the court through the relevant provisions of the Act, including Section 34, 36, 37, and 38, in order to delineate and distinguish the jurisdiction conferred on the authority and the appellate tribunal. It was submitted that while the Act doesn't confer powers upon the authority to draw proceedings suo moto in contingency contemplated and enumerated thereunder, no such power stands vested in the appellate tribunal. So you have certain suo moto power, but the appellate tribunal doesn't have. Learned Amicus submits that the issue which stands raised with the present petition is in any case no longer res integra, bearing in mind the judgment referred rendered by the court in Padam Singh Ji and others versus SVOGL Voice Gas and Energy Limited and others, which I very first slide said. And this is so beautiful because res integra, the meaning is an entire thing. It is applying to those points of law which have not been decided or which are untouched either by dictum or decision. So, this appellate tribunal had no power. There are 4 or 5 such judgments in the past. So, he is very clearly saying res integra. There were no powers. He submits that the aforesaid decision, through though rendered in the context of the other powers that was under the Debt Recovery Tribunal, constituted under the provision of Recovery of Debts and Bankruptcy Act 1993, would apply on all fours to the issue of which arises in this petition and enable the court to appreciate the circumstances in which powers suo moto may be exercised by a statutory tribunal or appellate body. In Padam Singh, which I touched upon in single line in the very first slide, that the court, upon noticing the provision made in 1993 Act, that we note that very same DRAT in the case of Bangu Company and Mittal and Garg Enterprises, DRAT has entirely held that the tribunal cannot exercise suo moto powers, interfering with the action resulting in prejudice being caused to the appellant before it in that case. In that para, it was held that firstly, I must say that these debt recovery tribunals are constituted under the RDB Act. The powers to be exercised by the tribunal are distinct from the powers to be exercised by the Honorable Supreme Court or and the Honorable High Courts, which are constitutional courts and are vested with plenary powers also. I must record here under that a tribunal functioning under RDB Act are not vested with such plenary powers, but derive their powers only under the Act. I have not come across a provision. There are no provision under the entire Act. So, sometime in legal practice, bare Act or precedents or previous judgments are more important than general notion. Which confers suo moto powers, nor semblance of conferment of such powers could be gathered from the entire text of the Act. Though Section 22 of the RDB Act provides that the tribunal and the appellate tribunal shall not be bound by the procedure laid down in CPC, but shall be guided by the principle of natural justice and subject to other provisions of the Act and rules, shall have the power to regulate their own procedures, including places at which they shall have their sittings. I do not think this provision could be interpreted to say that the tribunals have suo moto powers. Therefore, I am inclined to say that the view taken by the tribunal that it can exercise suo moto powers to interfere in a given case may not be a correct position at all. In any case, we are of the view the issue whether the DRAT have the powers to suo moto initiate any proceeding is no more res integra. Again, I said it is already decided res integra means. So, in view of the judgment of the Supreme Court in the case of Standard Chartered Bank versus Darvinder Bhobi, wherein SC, while considering the provision of the same Act, held as under that tribunal may make such orders and give such direction as may be necessary or expedient to give effect to its order or to prevent abuse of its power to secure the ends of justice. The aforesaid provision makes it quite clear that the tribunals has been given power that under the statute to pass such order and give such direction to give effect to its order or to prevent abuse of its process or to secure the ends of justice. Thus, the tribunal is required to function within the statutory parameter the tribunal doesn't have any inherent powers, and it's limited that section 9 subclause 25 confers limited powers.
तुझे जीएसटी डिपार्टमेंट मध्ये ना एक जीएसटी परीक्षेला एक ट्रान्झॅक्शन करून आले इच अँड एव्हरी ट्रान्झॅक्शन तुम्हाला एक्सप्लेनेशन द्यावं लागेल त्यांना हा मग ते होतील ना तुम्ही टर्नओव्हर केलाय टर्नओव्हर असं पण तुम्ही नंबर कॅन्सल काय केला नंबर काय आपण बिझनेस बंद केला
Vinayji, please mute.
Somebody is not muted, please.
तुम्हाला पैसे येणं होतं बिल नाही करते
Vinayji,
असं मी प्रूव्ह केलं
Aditya, somebody please get muted, please. Yeah. Next para says that we may refer to a 3-judge bench decision in Upper Doab Sugar Mill Limited, and wherein it has been held that when the tribunal has not been conferred with the jurisdiction to direct or refund, it cannot do so. It can do only what has been empowered to do so. The same principle has been followed in Union of India versus Orient paper. In another case, in Union of India versus Madras Bar Association, the constitutional bench, after referring to the opinion of Justice Hidayatullah in a particular case, the pronouncement in so many cases, these are all cited very clearly. Though both courts and tribunal exercise judicial powers and discharge similar function, there are certain well-recognized differences between courts and tribunals. This is very important. That there are differences between a court and a tribunal. Courts are established by the state and are entrusted with the state's inherent judicial power for administration of justice in general. Tribunals are established under the statute to adjudicate upon disputes arising under the said statute or disputes of a specified nature. Therefore, all courts are tribunals, but all tribunals are not courts. Courts are exclusively manned by judges. Tribunals can have a judge as a sole member, or can have a combination of a judicial member and a technical member who is an expert in the field to which the tribunal relates. Some highly specialized fact-finding tribunals may have only technical members, which are very rare and exception. And the third part was that 5 courts are governed by the detailed statutory procedural rules, in particulars of Code of Civil Procedure and the Evidence Act, requiring an elaborate procedure in the decision making. Tribunals generally regulate their own procedure, applying the provision of the Code of Civil Procedure only, wherein it is required, and without being restricted by the strict rules of the Evidence Act. We discussed this in the beginning also. From the principle that have been called out by the Constitution bench, it is perceptible that a tribunal is established under a statute to adjudicate upon disputes arising under the said statute. The tribunal under the RDB Act has been established with a specific purpose, and we have already focused on the same. It is duty to is to see that disputes are disposed of quickly, regard being had to the larger public interest. It's also graphically clear that the role of the tribunal has not been fettered by the technicalities. The tribunal is required to bestow attention and give priority to the real controversy before it arising out of special legislation. As has been stated earlier, it is really free from the shackles of procedural law and only guided by fair play and principle of natural justice and the regulations formed by it. The procedure of tribunal has been appropriately stated in section 19 of the RDB Act. It is apt to note that section 34 of the Surface Act. Now this is another section also where it says civil court not to have jurisdiction. No civil court shall have jurisdiction to entertain any suit. This particular clause under Surface I said, in respect of any matter which a DRT or a appellate tribunal is empowered by or under this act to determine, and no injunction shall be granted by any court or other authority in respect of any action taken or to be taken in pursuance of any power conferred by it under this act. So like we have Grahak Panchayat where we are allowed to go, or you can have some similar situation in other matters also. Section 38 of the RDB Act provides that the said act would have been overriding effect. We have referred to the aforesaid provision to be singularly highlighted that are the sacrosanct purpose with which the tribunals have been established is to put the controversy to rest between the bank and the borrowers. The stakeholder in this case will be real estate buyers and promoters and developers, and any third party who has acquired any interest. They have been conferred by jurisdiction by a special legislation to exercise a particular power in a particular manner as provided under the Act. They cannot assume the role of a court of different nature, which really can grant the liberty to initiate any action. They are not at liberty to take any action against the bank, in this case against the other stakeholder. They are only required to decide the list that comes within their own domain. If it doesn't fall within their sphere of jurisdiction, they are required to say so. Taking note of submission made by at the behest of an auction purchaser, and in this particular case, then proceeded to say that he is at liberty to file a stay application against the bank for omission committed. It has no sanction of law. The said observation is wholly bereft of jurisdiction and undoubtedly is totally unwarranted in obtaining factual metrics. Therefore, we have no hesitation in deleting the observation, namely, liberty is also given to the auction purchaser to file action against the bank for any omission committed by it. From the reading of the aforesaid paragraph of the judgment of the Honorable Supreme Court, it is clear that the tribunal doesn't have inherent powers. It is limited to such orders and such direction to prevent abuse of its process or to secure the ends of justice. This is again repeated different places. The same almost same judgment was quoted in other matters also. The courts established by the state are entrusted with the state's inherent judicial power or administration of justice in general. The DRAT or the tribunal having been established under a statute to adjudicate upon disputes arising under the said statute or disputes of a specialized nature by regulating the procedure applying the provision of CPC only where it is required. Now, like we have IBC also, that's some of the matters cannot go to the other courts. Tribunal are required to function within the statutory requirement. The tribunal have been conferred jurisdiction by a special statute to exercise a particular power in a particular manner as provided under the Act. The tribunal are required to decide the list that comes within their domain. A coordinate bench of this court, in the case of Prem Kumar, has also held that a litigation brought before a DRT especially involves a civil dispute. It concerns primarily the claim of a bank or a financial institution to a debt which it seeks to recover from the person implicated as a defendant. In dealing with such an application instituted for it by the bank, the DRT may not be strictly bound by the procedure laid down in the Code of Civil Procedure or may have been vested with the power to regulate its procedure. But there is nothing in the statutory provision to indicate that the procedure which DRT adopts may be what it fancies. This is court was very harsh on this DRT judgment, and this judgment came in 2018, and in 2022 RERA tribunal passed the same almost similar that they have taken a suo moto action against a particular stakeholder. As noted earlier, section 22 confers upon DRT certain specific powers vested by the Code of Civil Procedure in the Civil Code. These include the power to enforce the attendance of a person. But the rider is that the attendance being enforced must be within the objective of examining him on oath. Necessarily, a person required to attend to be examined on oath would be a person called as a witness and not a party to the suit. We are discussing this because this is ultimately affect our tribunal, RERA tribunal also. The clauses have leave no room for doubt that for regulating and appearances of parties and consequences of their non-appearance, DRAT is to be guided generally by the provision contained in the order of Code of Civil Procedure. If the applicant under section 19 fails to appear, application may be dispersed in default. Conversely, if the defendant duly served doesn't appear, proceeding can be held ex parte. Application dismissed in default may be restored upon application being made on sufficient cause being shown that it is to be set aside. Similarly, defendant having been set ex parte may again rejoin the proceeding and may be permitted to participate and ex parte proceeding being set. This is all allowed at the tribunal level. Even that somebody doesn't appear ex parte. Ex parte again goes into for a relief application. He is entertained and then it is resulting into being reopened. The forums constituted under this are not criminal courts. They are civil courts. To put simply, they do not adjudicate upon criminal causes or criminal charges. There is nothing in the provision of the statute which establishes them to show that they are vested with any powers of the criminal court. These tribunals are expected to follow and be guided by the principle of natural justice. Their obligation is to ensure that no one is condemned unheard. Their application is to ensure that a dispute brought before them is adjudicated upon after both the sides have been given power of opportunity of being heard. It is inherent in this that having issued summons to the defendant, the tribunal must ensure that the process is duly served. लेकिन नहीं आता, then it is okay, they can proceed. But in popularly in section 138 and 142 negotiable instrument act, this game is played for years. एक को डिफेंडेंट को नहीं दिया, इसको समन नहीं किया, ये इसको समन ही सर्व नहीं हुआ, declare him that he is missing. This game is done by the legal fraternity over a long period, but for us up to tribunal this is not required. So it says that to show cause as to why relief prayed for should not be granted. If the defendant duly served chooses not to appear, he suffers ex parte decision. Tribunal is within the jurisdiction to set such a defendant ex parte. When he comes back, नहीं मेरा कुछ रह गया था, some other materials comes into record. So all said and done, that generally speaking, no obligation on the part of one defendant to ensure the appearance of a co-defendant unless there is a material to show collusion or one is the agent or a principal of the other. The provision contained in RDBA Act 1993 has been referred by the DRAT in the impunged order. The clause reads that tribunal may make such orders and give such direction as may be necessary or expedient to give effect to its order or to prevent abuse of its process to and secure the ends of justice. All this judgment, this beautiful line is printed, but whether it is really been done or not, here, our own tribunal overstepped. In the specific context of the Supreme Court also said in Standard Chartered Bank, which we report cited in the previous slide, held that a DRT is required to function within statutory parameters and the tribunal doesn't have any inherent power and it is limited that this particular section has limited powers, confers the very limited power. We do not approve of the observation of DRAT. Mind you, we are talking about our RERA tribunal, but this judgment was discussed at a DRAT because it was already decided, and Delhi RERA tribunal took a suo moto action. And in the initial stage, I said why the court did not had stricture or reprimand them because of their intention and the facts of the case. Because it is as res integra, it was already decided. We do not approve the observation that the above noted clause confers upon DRT jurisdiction akin to the one vested in the High Court under section 482 of the Code of Criminal Procedure. The language employed in the two provisions may be similar, but the import thereof cannot be equated. The provision of section 1925 of the RDB Act may at best be compared with the one contained in section 151 of the Code of Civil Procedure, which saves the inherent power of the civil court to secure ends of justice or to make orders to prevent abuse of judicial process. It is trite that such inherent jurisdiction to render justice cannot be taken resort of as to nullify the other statutory provision put in position to regulate the procedure. How do you regulate the regulator? Right, sir? And of course, you cannot override the law of the land. So, where the legislation deals expressly with a particular matter, the provision so enacted would normally be regarded as exhaustive. The principle laid down in Padam Singh Ji were reiterated by the court in Sri Satyanarayan Rao also where also again learned amicus was appointed, and he submitted that two decisions noted above clearly hold that tribunals and appellate tribunals constituted under a statute do not stand conferred with any inherent powers. It was submitted that suo motu must be found to have been specifically conferred by a statute. Absent of such conferral of jurisdiction, the learned amicus would contend the tribunal or appellate authority would have no jurisdiction to do proceedings of its own motion, suo motu. It was submitted that while the authority under the Act doesn't stand conferred the power to draw proceedings suo motu in certain contingency, absent such a power being conferred upon the appellate tribunal, the proceeding impunged here are liable to be quashed. And in the next slide, we have covered that why silent is not a legislative intention also. Because silence of the legislation doesn't mean that it conferred or it agreed. The learned amicus commented for the consideration of the court that the appellate tribunal here was admittedly not in session. Now, not in session means it is a legal term where the possession of something, the right to possess, that is the legal meaning. So, not in session of any appeal or petition directed against an order passed by the authority. In view of the above, Mr. Mehra submitted that drawal of proceeding by the appellate tribunal was patently without jurisdiction. To appreciate the submission address, it would be apposite to notice that the relevant provisions of the Act in terms of which authority and appellate tribunal have come to the constituted. The appellate tribunal has been constituted. Now we talk about Delhi RERA. The 43(1) said that within certain time court. So we will go to by these slides little faster because this says that we have already covered in chapter 19 inherent powers, and so it's said that what is how to establish the real estate appellate, then within 1 year. Then it also says that some of the states, smaller states or neighboring state can have a combined tribunal also. Or it also said that all matters pending with the appellate tribunal designated to hear appeal shall stand transferred to the appellate tribunal so established and shall be heard from the stage of such appeal is transferred. That stage of appeal also can merge at certain places. Any person aggrieved by any direction or decision on in order to by the authority by the adjudging officer under this act may prefer an appeal. You can have a appeal also provided when a promoter files an appeal with the appellate tribunal, it shall not be entertained without paying of fees and all that. So this is about central act also is followed mostly in by all the state. This is RERA Delhi. As is evident of reading 43.5, tribunal is empowered by the Act to hear appeals that may be instituted by any person aggrieved by a direction, decision, or order made by the authority or by adjudging officer. Then it also talks about powers of the tribunal. That it is not be bound by the procedure laid down by the Code of Civil Procedure 1908, but it shall be guided by the principle of natural justice. Subject to the provision of the Act, the appellate tribunal shall have power to regulate its own procedure. Appellate tribunal shall also not be bound by the rules of evidence. As I repeatedly said, that Indian Evidence Act may not be strictly complied with or followed also. The appellate tribunal have the powers for the purpose of discharging its function. Same in the very fourth or fifth slide, I said that summoning, issuing commission, all proceedings shall be deemed to be judicial proceedings. So this is the same. We'll skip this because it says in the last line that chapter 16 of the Code of Criminal Procedure 1973 will be deemed to be there. The authority, on the other hand, owes its genesis to section 20. And it is reproduced here that establishment and incorporation of a real estate authority. So again the same previous slide, this again is repeated that it will be within 1 year. You can you must have or there will be more than one authority, more than one state can also have. Then there could be common seal power subject to provision to acquire, hold, and dispose of property, both movable, immobile, be should or should. Then section 31, filing of complaints. So here again, filing procedure, filing fees, complaint procedure. As some of the eras, some states have the SOPs also under this. So how you file the matter. 34 section says functions of authority. The function is to register and regulate real estate project and real estate agents registered, to publish and maintain a website of record for public viewing of all real estate project for which registration has been given, with such detail as may be prescribed, including information provided in the application for which registration has been granted. Not granted is not included, not registered is not included, not liable to be registered is also not included. To maintain a database on its own website for public viewing and enter the names and photographs of promoters as default, including the project details, registration for which has been revoked or have been penalized under this act, with reasons thereof, for access to the general public. To maintain a database for public viewing, names and photographs of the estate agents similarly. To fix through regulation each area-wise fees to be levied, ensure compliance of the obligation cast upon the promoters, allottees, and real estate agent. To ensure compliance of its regulation or orders of direction made in exercise of its power under the Act. To perform such other functions as may be entrusted with to the authority by the appropriate government as may be necessary to carry out the provision of this Act. So previously, that previous judgment cited were discussed for that particular act. Now this is each section of RERA Delhi is also discussed at length, and then fact finding, and then later on it was analyzed and judgment was pronounced. Section 35, 36 and 37, which have been a significant bearing on the question of which stand post in this present writ petition, is also reproduced here. 35 is powers of authority to call for information and conduct investigation. Where the authority considers it expedient to do so on a complaint or suo motu. This is mentioned here. Relating to this act or the rules or regulation made therein, it may by order in writing and recording reasons therefore call upon any promoter, allottee, real estate agent, as the case may be, at any time to furnish in writing such information or explanation relating to its affair as the authority may require, and appoint one or more persons to make an inquiry in relation to affairs of any promoter, allottee, or real estate. Notwithstanding anything contained in any other law, it again says the Civil Procedure 1908, discovery and production of books of accounts. Such place and time, such time as may be fixed, specified by the authority. Summoning and enforcing the attendance of person and examining them on oath, issuing commission for the examination of witnesses, any other matter which may be prescribed. Nowhere this is covered. Power to issue interim orders. There could be interim order also. Powers of the authority to issue direction. This is repeating, so I'm not taking you to the whole slide, but this is power to issue, power of authority to issue directions. Then the 15th clause of the judgment says that in exercise of the powers conferred by section 84 of the Act, the central government has framed the NCT Delhi RERA. This was under the power central government under the section 84 of the Act. NCT Delhi RERA was formed. Rule 25 specifies certain additional powers, which are again same. Almost everybody has the same, that it requires promoter, already real estate to furnish in writing information, requisition any record, document or copy, even from any of these other authorities also. The authority may call upon such experts as engineer, architect, a banker, anybody can be the authority may in the interest inquire in the payment of amount imposed as penalty, uh, withdraw the said amount from the account maintained under that particular clause, use amount paid to such promoter by the allotee for the real estate project for which penalty, interest or compensation is payable for, or any other real estate project, or recovered from the amount paid as penalty also. Similarly, additional powers which are conferred on RERA Tribunal Delhi in Rule 19, additional powers. Again, this they were the same power that they have to furnish in time, requisitioning evidence that then they may call for a expert from accounts, economic, commerce, law, engineering. In 17th clause of the judgment says that in order to appreciate the challenge which stands raised in the present petition, it would be at the outset be relevant to contrast the power and jurisdiction which the appellate tribunal and the authority are conferred with under the provision of the Act. It is evident from a reading of section 43 and 44, it is manifest that the appellate tribunal has been constituted as a forum whose jurisdiction may be invoked by any person aggrieved by a direction, decision of the order or made by the authority or an adjudicating officer. Section 43 and section 44 of the Act do not confer, do not recognize, do not envisage any original or plenary power or authority being exercised by the appellate tribunal. The authority of the appellate tribunal stands confined to consideration of the challenges that may be laid to orders passed by either the authority or the reading authority. The Act doesn't vest or confer any authority or jurisdiction upon the appellate tribunal to initiate proceeding on its own motion. That is again what suo motu. Turning then to the provision of which deals with the constitution and powers of the authority. It is manifest that it is obliged to regulate real estate project. Yes, it is accepted. To ensure compliance of obligation placed on promotees, allottees, agents. Section 35, where a complaint is received by it in respect of any, it is empowered to call upon promoter, allottee, estate agent to furnish information in writing or orally or explain its affairs to the authority. Then it can be set in motion either on a complaint or by the authority itself acting suo motu. Section 35 confers on the authority the same power as are vested in civil code under the Code of Civil Procedure 1908 insofar as they pertain to discovery and production of books of accounts and documents, summoning and enforcing attendance, issuing commission, again same repeating, calling expert and everything. Section 36 empowers the authority to issue interim orders. This very provision also empowers the authority to issue interim orders even ex parte also. As I rightly said that some of these powers are there, the evidence may not be there, attendance is not mandatory. And people are taking benefit of this, they come back and they say that, okay sir, you rehear me. This is also abuse. But authority in terms of section 37 is invested with the power to issue direction from time to time to any promoter, allottee or real estate agent prescribed that such direction would be binding on parties concerned. Rule 22 enumerate the additional powers which may be exercised by the authority, and it is referable to the provision contained in section 35(2) clause 4. Similarly, Rule 29 spells out the additional powers. So we have discussed everything: powers, additional powers, inherent powers, formation, everything by the appellate tribunal, and thus amplifies and provides content to the mandate of section 53(4)(g). On a consideration of the aforesaid provision as made and incorporated on the Act, it is manifest that the appellate authority cannot be recognized as conferred with the power to initiate proceedings suo motu on its own motion. This is evident from a reading of the provision. Now we are reading and interpreting each section of Delhi RERA, where the powers were there, engrafted in the statute and which enumerate and circumscribe the jurisdiction of the appellate tribunal. The appellate tribunal, it must be remembered, is a creation of a statute It is not an authority which may be recognized as being vested with inherent powers. Regard must also be had to the fact that the appellate tribunal is not part of the hierarchy of the traditional judicial institution which constitute the judicial system of our country. It is an appellate forum whose origin and formation stems from the provisions of the Act. It is in that sense an adjudicating authority which owes its existence and authority to a special statute. Viewed in that light, it is manifest that it can neither assume nor arrogate to itself a power or authority which may be otherwise not stand conferred on it by the act. Simple मैं मतलब public property मैंने ताज को बेच दिया आपने मुझे दे दिया मैं ताज महल is my public property. You are not empowered, I am also not empowered. It's simply overstepped jurisdiction. There is thus an evident and blatant assumption of jurisdiction which otherwise doesn't stand vested upon the appellate tribunal. The court thus comes for the conclusion that the impunged order proceedings are the clearly ultra vires the act. The whole judgment, beautiful judgment for few months, everybody was happy. The court further notes that a patent lack of jurisdiction stands further highlighted when one compares the jurisdiction conferred upon the authority and the appellate tribunal. As it is clear from a reading of section 35, the power to do proceedings suo moto power stands specifically bestowed on the authority. There is, however, a conspicuous and evident absence of extension or conferral of similar powers on the appellate tribunal. I previously spoke about it, that legislation intention keeping silent. This is in considered opinion of court is not liable to be construed as a legislative silence. It was the intention not to include. That is why legislation was silent on this. It is in fact and to the contrary positively indicative of a conscious and evident legislative intent of not conferring similar powers upon the appellate tribunal. The court thus comes to the conclude that there was a patent lack of jurisdiction and the proceedings as drawn by the appellate tribunal are liable to be quashed in entirety. But last paragraph of the judgment again it gives some relief to the not liable to liable project which are liable for registration. Otherwise, it have been very grave miscarriage of justice. Turning then to the impugned orders passed, the court notes that the order of 17 November had not even been passed with the appellate tribunal was in session. Again, I am saying that is it is saying that possession of something, right to immediate possess. So, in not in session of any order or direction made by the authority or the editing officer. The court also note that means there was no direction whether original or appel. It was not a judgment against which somebody went into appeal. The court also note that the order of 17 November proceeds on the basis that there is a rampant non-compliance of the provision of the act within the NCT. Though I may not agree with this is very evident. Everybody knows that in Mumbai also it is rampant non-compliance. But with due respect, I cannot make further comment on this. The appellate tribunal also took cognizance of a report submitted by its registry, which appears to have alluded to the allegations of innocent people being duped. How can you have allegation? It is open fact that innocent people are duped where real estate agents and housing developers who were implementing projects in the area falling under the land pooling policy of the DDA. It seems to have issued various communication to the Commissioner of Police seeking details in respect of these projects and consequent to no details being proffered, it is proceeded to register the case soon. This particular last line it helped. Otherwise, there could have been constitutional challenges, there could have been reprimand, and that in spite of already pronounced Supreme Court full bench judgment, why did you overstep the jurisdiction? They can take action. But here they saw that nobody, or Commissioner of Police, Lieutenant General, Municipal Commissioner, Chairman, DDA Chairman, nobody bothered. So they accepted that appellate tribunal has exceeded its jurisdiction because of these reasons. Next. On 24th November 2021, the Appellate Tribunal went even further and framed the omnibus direction. It gave a general stay restraining all construction activities, be it residential or commercial, in the entire NCT of Delhi. The aforesaid direction was to cover all projects which failed to register. The court net that section 3(1) prescribed that no promoter shall advertise for which there are exemption 500 square meter hai, 8 unit hai, but here everything was included. Even the it says that first provision says that in case of ongoing projects, then which are under different stages of implementation on the date of commencement of the act, in respect of which a completion certificate may not have been issued, will also required to be registered within 3 months from the date of commencement. Prior registration of real estate had exemptions that area of the land is not exceeding or units are not exceeding. Same thing is again fully then till then you cannot advertise sale or so we'll skip that slide. 23rd uh, paragraph of the judgment says it would be relevant to note that the act came to into force on 26 March 2016 in Delhi. As this court views section 3, it is manifest that the same would principally apply to projects which may commence thereafter. In light of the mandate of 3(1) and insofar as ongoing projects are concerned, they would stand governed by its first provision. Similarly, 3(2) specifies various contingencies in which real estate project may be exempted. Previously, 500 square meter, 8 unit. So, very clearly it said that it is nothing was mandatory compliance. It is requirement of registration is one which necessarily merits an inquiry or examination of the facts of each real estate project before the authority or the appellate tribunal may come to a conclude that registration is mandated. This court finds it unable to appreciate the omnibus direction. The appellate tribunal clearly and abjectly failed to bear in mind that true ambit of section 3 proceeded on the incorrect and unfounded premise that all projects were liable to be compulsorily registered under that. Here, this was the failure. Unfounded premises that all projects, they state all the projects. So, uh, this was also mistake here, could be. So, we can take a relief that if it is liable to be registered, then this judgment will not apply. The court also takes into consideration the significant portent of the direction issue. It has particularly injected all the construction activity in the entire NCT of Delhi. The aforesaid injection is not shown to have been preceded by any inquiry with respect to the validity of a particular project or even a prima facie assessment or evaluation of the validity of a single project. Even one project was not analyzed. In fact, the order doesn't even take note of a proven or evident violation of the provisions of the act by a particular project. This court is constrained, here is this, it was constrained to observe the procedure as adopted by the appellate tribunal can neither be countenanced nor occurrence and imprimatur. But luckily, it survived. So, the last paragraph, the judgment says that accordingly and for all the aforesaid reasons, the instant writ petition is allowed. The impunged orders of 17 November 2021 and 24 November are hereby set aside. For reasons aforementioned, all proceedings relating to suo moto case number REAT 0002 2021 shall also stand quashed. This last line is a little relief. This judgment shall have not to be construed as restraining the authority from independently examining the validity of individual projects and enforcing the provisions of the Act in accordance with law. This is a saving grace and last little relief. Thank you very much, friends. I thank my staff, Vaishali and Mayur to help me in this, and my daughter Jasmine Purani, who is a junior associate in criminal matters at AMD Legal, for this compilation. Thank you very much. If the convener permits, we can have some further discussion or some question answer on this.
Extraordinary session, Purani sir.
Thank you,
You
sir.
have very lucidly and in detail everything you have covered. Not only the particular which we could have expected about the suo motu. So many other things you have clarified as a practicing chartered accountant in this area, right? Yeah. Before I go for the vote of thanks, I will request members if you have any doubts, questions, because ultimately this group is a study group, right? And we all are members of this group. So I will invite each one of you. If you have any query, one by one, please raise, unmute yourself and please raise your question. Either Atul Saab will answer or some other person might be, because maybe any of the query during this last month we might have developed, and that might be, we may search the answer of that query. And this is the right platform where we can deal with all or any kind of query related to RERA. Yes.
दिलीप सर, as we always discuss, वो 25 में से अभी तो 15 ही दिख रहे हैं. So people maybe by long presentation fled.
Sir, might be there are professionals who are mainly certification and audit. They may not be in the litigation practice. Maybe.
Yes, right. That is why I included, even I explained legal meaning of certain legal terms also, because we
Yes,
all
sir.
of us are
Yes.
not in litigation. Right?
Yes. Right. Yes. At least everyone should ask one question or say something about what you know, which you think that is important. Should others also know? Everyone, please say at least one or two lines from your side. This is the study group. As we have discussed in the last meeting, everyone being part of the study group is contributor. And standing there, don't worry, whatever you will share, we will take it very positively. We all are family members of this study group.
I saw Saransh there. He's a legal fraternity.
Correct.
And,
He is a very good speaker also, I think.
so
Karan,
if I see him missing now, he was there. So I thought he would come and because he's a better position in this matter.
correct, correct. He is expert.
Yeah.
If I take the privilege, I will request one by one. I will call name. Please unmute yourself. At least video and mic you should start. Everyone, please have your video and mic started. Everyone, I
So,
request everyone, please unmute yourself and keep your video on.
Dilip sir, there is one question in chat box.
Yes, please, sir. Not chat, sir. You read out. You directly chat with the speaker.
Nikunj.
Yes, sir. Am I
दिलीप
audible,
सर
sir?
Yes, yes.
Yes, sir. Yes.
You are
स्क्रीन
audible.
शेयरिंग ऑन कर दीजिए ना तो वी कैन सी एवरीबॉडी.
Uh, Thank you so much, sir. This was a great session. I thank the organizers and the speaker. Sir, I just had a general query for discussion. Sir, promoter has obtained OC and uploaded Form 4 on the RERA site. Does his work stop there, or he still has to do some compliance after this? This might be a very basic question, but sir, I'm just starting my trying my hand in RERA practice.
Yes,
So
sir.
it will be
Yes.
great to hear from all of you about this.
Yes, whatever questions you have, sir, it is most welcome because this platform is for everyone, including those who are starting their practice in RERA.
Thank you, sir. Thank you.
Yes. Uh, yes, Aditya, can you answer that?
Okay. So basically, with respect to
दिलीप सर
Form
ये
4,
पीपीटी को
see,
ऑफ कर दीजिए.
अतुल सर पीपीटी को ऑफ कर देंगे. सिर्फ नीचे स्क्रीन ऑप्शन है ना, स्क्रीन बटन है, उसको क्लिक कर दीजिए. कैमरा के बाजू में नीचे. एस्केप, क्लिक एस्केप, अगेन एस्केप, और आपका जो गो टू वेबिनार है ना, ये भी पीपीटी बंद कर दीजिए.
क्लोज कर दीजिए।
क्लोज कर दीजिए।
नहीं, उनका स्क्रीन शेयरिंग ऑफ करना पड़ेगा। माइक कैमरा उसके बाद में मोर होगा सर। मोर पे क्लिक कीजिए एक बार, 3 डॉट्स दिख रहे होंगे। आदित्य सर आप कंटिन्यू कर सकते हैं।
Okay. So basically, Form 4 and Form 3, Form 4 and OC, once the promoter has uploaded that on the website, the responsibility of promoter doesn't stop there, because if you will see that conveyance needs to be done to the society within 3 months of obtaining OC. So till the time conveyance is done, he has to keep on updating the status every quarter of regarding the conveyance on the website. Obviously, it will be considered as a completed project, but as per the order relating to conveyance, he has to keep on updating the status there.
Okay, sir. So basically, he will not be required to upload any forms, 1, 2, 3 forms,
Correct. He is not
but
required to upload any
how does
forms.
he keep on updating that status regarding conveyance on the
There is
website?
a separate tab. There is separate tab relating to conveyance on the website, wherein he has to status of conveyance. So there he has to keep on updating the status of conveyance every quarterly.
Okay, sir. Okay.
Yeah, with now there might be certain changes, right? Rather major changes on the website from 30th June, 12 a.m. So accordingly, we might get certain options also. Already we can see there are certain options introduced. So let us see what other options they are introducing there in the portal.
Okay, sir. Sir, WRC had released a book on RERA. I guess last year this was released. Any chances we will get a new version of this once this site is updated with new?
Yeah, definitely. We will work on that also for the second version. All the authors will work on that also. So we might get.
Thank you so much.
Atul sir, I have a question.
Yes.
Sir, I just wanted to know that now we had an order number 29 also, wherein RERA stated that to initiate certain actions, they cannot be called as suo moto. So we have to apply. So please provide us insight that how this will work co-jointly, because once we when in this particular order, what I have observed that they are stating that suo moto actions cannot be termed as suo moto. The concerned aggrieved person has to apply for that based on the adversarial matters, which they haven't clarified which adversarial matters. And in the suo moto proceeding judgment which you have taken, there they have mentioned that the suo moto actions can be taken by the authority and not by the tribunal. So how
See,
this can be?
yeah. As such, notifications and circulars are not binding on the authority, and it cannot be final or binding on us, other stakeholders. But I don't know why. Maybe they were scared of this judgment, or they've initiated this because they have the powers. You are right, but and to that extent that grahak panchayat or anybody can file for that. Suo moto powers are there, very much there. Even this judgment also is very clear that suo moto powers are there for this. So why this notification has come, it may be it's a matter of wonder, and I'm not in a position right now to answer this because I'm very clear that no suo moto we have to, but then for that also you'll have to apply, because if you argue that no you have the suo moto power, you have to appeal, so ultimately it will kahan se bhi karo it, you have to go and through your client or on your and go to the authority and
Because in that order, they haven't clarified two aspects. What matters will be considered as adversarial,
yes,
and
absolutely.
secondly, which are the sections under which we can apply. Suppose if there is delay on the part of the BMC or any municipal authority for issuing certain NOCs or certain permissions, so whether
Yes.
we can use that order and we can file a particular matter with the authority, so that they can provide any guidance or such order to the BMC for releasing the
See, they
permission,
want to
because
shrug off.
that will
They
release
want
the.
to they want to shrug off their responsibility because this is a old trick of the trade that don't get certain permissions. Builders will not get certain permissions, and then particular section doesn't envisage this situation. That now you can go and that this guy is not taking phase wise permissions or BMC is not sanctioning. Then he would turn and say कि मेरे पास सर मैंने तो 10 बार अप्लाई किया. So probably that situation you can go for a appeal. It's not suo moto, and nobody wants to take a suo moto action. We are already delays in table one, table two, and all that. So this will increasing there. So maybe one of the procedural problems they might have come out with this notification.
Okay.
Yes.
Thank you,
Uh,
sir.
I have few questions, Aditya ji. Most of related to anyone can answer. Number one, uh, what if builder has not completed the common amenities, or there are some after OC problems, and then society is filing a complaint against the builder? Is there any specific complaint form? I want to know the form number. Like A and B, we know A for the authority, B for the adjudicating officer, whatever is prescribed, right? Is there any form for society to file, or only form A will be filed?
So there is no specific form for the society, and moreover, they are called as they are co-promoters in this as per the act.
Aditya is absolutely right. We are co-promoters, and my own society and adjacent society, three building, 4 years, only 4 floors have come up. I'm speaking on this topic, and then I'm not having any relief. We are in the process of going to the court, but it is very sad situation. There, it doesn't have the form. You are a co-promoter. It's very clear. You can't. That's why it is not there. That's why when you were talking about form A and B, you are not co-promoter is not to be included into this. That's
Sir,
what
there is
my
a difference. Yeah, right, right. Good that you at least clarified something which is also pertinent. But question is, if the project is completely new and the builder has formed the society, and now the LOTs have become member of the society, and the promoter's work is pending, something he has not completed, and then this association of LOTs by way of the society, they are going to file complaint, right? I'm asking about this.
So then,
No, sir.
defect liability period also, we have a provision that 5 years defect liability period is there. So under that also he can be prosecuted. And moreover, I think so we can take a benefit of order number 29 also if there is no OC, and it
OC
is a
has come.
responsibility to obtain OC.
OC has come.
Okay.
Builder has given permission to all the LOTs. Only thing is there are certain common amenities which they have not completed,
Okay.
and that is
So
subject to those things. OC has been issued by the BMC, subject to completion of those things, and therefore society members by way of the society, they have filed. I have seen one of the case where they have mentioned form number M. I could not find form number M anywhere in the act, right? Therefore, I asked, is there any form prescribed somewhere in the circular or regulation or somewhere, which is form number M? Or they have, some might be, some advocate might have brought from anywhere, Code of Civil Procedure 1908 or somewhere. I don't know. अतुल भाई आपका बंद है, म्यूट किया हुआ.
No, I'll also try and search and get back to you.
Yeah, okay. This is one thing which is just for knowledge sharing. And another part, uh, if we take up the redevelopment project wherein society is the co-promoter, obviously in the redevelopment project, but when the building is completed and new flats are additional flats, sellable component is sold to third party, they also become member of the society, existing society, right? In that case, if some common amenities are not completed, can they file or they cannot file after OC or some to bring 5 years defect complaints? Can they file? In my view, they can. But at the same time, there is a confusion because they are declared as a co-promoter or landowner promoter in the RERA site. In the given situation, by describing all the facts of the case and who are the new members uh, being member of the old society, and now they are coming through the society to uh, claim compensation or to get direction to complete the pending work by the promoter. Yes.
Sir, here I would say that many societies, after getting the OC, RERA registration would lapse. So whether that falls within the RERA is also casting apprehensions. And about file, as Aditya said, certain defects or certain amenities were not provided. That should fall legally speaking under this, but it will be out of, like I think day before yesterday there was article about certain projects getting out of because expired registration. Now that is also a very big amount. So here in your case at least building was complete without certain amenities. Yes, sir.
अहो मी
So
सेमिनार मध्ये आता.
Sir,
Yeah,
what
Aditya,
I
your
feel
take.
is
Yeah.
basically I feel that it should be entertained. But now what is the situation is RERA is concentrating on
हाँ
completion
सर.
of the project. And right now they are not accepting or rather not giving that importance to the defect liability period, or we can say the title insurance also. So here, according to me, it should be entertained because as a society it is considered as promoter, but individual members are always considered as allottees because they are the flat owners and other component, the sale component, they are the allottees. And most
absolutely.
importantly, if we see the Form
Yes, sir.
1, that is the architect certificate. There also we ask for the stage or the completion regarding the common amenities such as clubhouse and everything. So if their architect is mentioning, because without that, he should not give the Form 4 also. Because if the building is not fit for occupancy, we have seen in the past that RERA has taken action against an architect, and wherein even though the project was having OC, and still he gave a Form 4, but RERA said that uh, uh, if you are a professional, you should not sign blindly.
No, it should
So
not.
there, if it is not fit for occupancy and all the amenities are not provided, then it is not to be signed. So only OC is not important. The Form 4 is also important. That is the reason two of those things are very different. One is I'm giving the occupancy and one is fit for occupancy. These are two different terms. Moreover, if sanction plans, we can obviously challenge the order through order number 29. I think so. This is covered in the sanction plan. If sanction plan is covering the amenities, then the project is not yet completed with respect to those sanction plans. So obviously, these are the regulatory functions of the RERA, and we can file a complaint. According to me, we can go through the route of order number 29.
Yes, because on sanction plan, sometime garden is mandatory or sometime school, some amenities is necessary. Then, or an outsider allottee is also there. Then your argument is absolutely strong on this.
Uh, yeah. At least we could get some diversified clarification. It will give more confidence when we will be working on it, right? And one more question, say two, three small confusing questions or might be giving clarity to everyone. Say, Acha, Aditya, you are expert Form 3 and 5 in the C Institute, right? In my view, you are the most competent person. Say, so far in the recent circular, RERA says this Form 1, 2, 3 has to be given to the bank as well as to be uploaded on the MahaRERA website. Is it a public document or only for the RERA to be uploaded and they will keep it with them? Is it
Sir,
public document?
the Form 3 is not yet public. Form 1 and 2 is made public because it will give the real-time update of current status of the project. But Form 3, I have seen that when the buyer files a complaint, and if he is asking for public inspection of Form 3, then RERA sends an email to the developer that so and so buyer is asking for the Form 3. So whether we can provide the Form 3 to the complainant. So this is my observation in one of the case. So if it is given, the permission is given, then only they provide the Form 3. So it is very important document, Form 3. But yes, it is right now not available for download. But if any authorities have the they can have the power to ask for the Form 3, and for any search and survey procedures or anything in future, they it might take place. But obviously, this Form 3 right now is not available for download. But later on, it can be made a public, not public document, but as a part of the complaint. Because if the project cost or itself is challenged, because most of the things are revolve around the funds. So if funds are not available, developer is saying that I don't have the funds. So then the Form 3 becomes an important document, where exactly how he has spent the cost, and what is the notes they are mentioned by any chartered accountant.
Right. Now, question is, say your experience. Can you share about how LOT can approach RERA? Should they file mail? They send mail that they want to inspect the document, or they can go to RERA for the inspection
So
of
there
the
is a Form
documents by
6, Form number 6
Form
available.
7, Form number 7.
Form 7
Yes.
available. So through that they have to apply.
One has to go personally, in the RERA, and they
Yes,
should
yes.
request for the inspection, right? Any charge for the inspection? They have to pay? No.
No, I don't think so.
Okay.
There are no charges.
Okay. Perfect. I got that. Now, next question is, uh, if any promoter does not want to get RERA registration, right, and they are completing the project and getting the OC, and thereafter they start selling units, right? Whether RERA registration or consequences of RERA be applicable?
After OC, right?
After OC, yes, till OC, they don't sell, market, or offer for sale anything under Section 3. But after
So,
getting OC, they go public.
Yes, sir,
so
Atul ji.
small
Aditya
projects,
ji, sorry, sir.
small projects are indulging into this, and very successfully handled it also. But it is practically not possible for other people. One project, two projects, smaller buildings, it happens. What you are saying is happening, and
The
because
question is,
builders are not
the
willing, or
query
the
is from
consultants.
the smaller query is the from the smaller developer, because
Yeah.
those builders who are having suppose redevelopment agreement, and then smaller building they are making, because they know 5 6 flats if they want to sell, then lot
Yes.
of legal compliances they have to make, and
Yes.
rather than going for the registration and compliances, better they can complete by their own fund or borrowed fund, whatever manner they do. And
Yes.
I'm question is the legal, whether after OC they have to they are selling, because Section 3 says in the exceptions, 3 exceptions covers the OC. If the
Encumbrance.
OC has gotten,
Income.
then no need to
Income.
register, right?
Encumbrance.
If that is the view, then after selling, consider there are approvals or sanctions, or some defect liability comes, which I have heard from various speakers, that after RERA come into picture, even after OC, if the builder is selling the units, defect liability or some of the common areas things which they have not completed as per the plan will also be taken care. Then how it will be taken care? Without having registration, RERA does not register the cases.
Sir, there is a myth, and some school of thoughts may agree with your point, but I am also a school of thought that no, because even in this judgment also it says that if you are not mandated for registration, this will not hold good. So if in the past people are resorting to this for avoiding GST compliance and RERA compliance, and have successfully managed. Many buildings have come on within 5 years, where buildings are complete, people are staying there, and they have not yet come to the RERA for any defects or not. you may go to some specific performance Indian Contract Act violations or breach of violation. In my view, so sir, it is still not in the arena of RERA.
Okay, okay, I got that, sir. Aditya, you have any different view?
Yeah, I think so. It will not be covered under RERA because once the OC is obtained and they have accepted the amount after OC, so it is a ready stock available. Buyers can view the flat, they can see the whatever it is, and they can inspect and then they are buying. So they can have a much confirmed decision. Wherein under construction it is not available at the start. So they are completely dependent on the promoter for that flat. So here the situation is different, and I think so. Instead of RERA, it will be covered under MOFA. So there also we had a three years defect liability period. So it is not yet repealed. Only the contradictory provisions where there will RERA prevail. But if RERA is not the agreement is not registered under RERA, agreement is the model agreement which with that RERA is to be followed. But the defect liability period will be even though we have under MOFA, so that will be followed. And here it is not a under construction, so it is readily available. So buyers have a more confirmed decision and they have the OC, so they can inspect whatever is given, whatever amenities are given in the flat, and accordingly they can buy. So those two aspects differ. That is the reason RERA, when registered under RERA, the view is different, and not registered and having an OC and then accepting the amount is a different, altogether different. So
Yeah,
there is
got
no
it.
risk involved.
I agree to this because as in these slides when we discuss about legislative silence on this, so as Aditya rightly said, you need less protection when you buy a lock and key flat, yeah, rather than under construction.
Yeah, yeah, right. And then I can, Lalit ji,
Lalit
your
sir,
expert view. Lalit ji, your expert view,
हाँ
please.
हमारा
सर अभी
डेडिकेटेड वॉरियर ललित आज एकदम चुप है, हल्लो भी नहीं किया उसने.
नहीं सर किया ना एक्चुअली वो ऐप शायद डाउनलोड नहीं था मेरे आईपैड में, तो वो डाउनलोडिंग में वक्त लगा जब तक आपका शुरू हो गया था सर. सॉरी फॉर दैट सर. हेलो, गुड
ललित आज
इवनिंग.
गाड़ी नहीं चला रहे हो, हमेशा गाड़ी में ही होते हो तुम तो.
हाँ अभी घूम के आया हूँ सर 15 दिन अच्छे वादियों में. होटल बिटल देख के आओ, क्या डोंगर वगैरह पण बघून आलो रे मी. जोगा पार्ट. अभी लेक्चर जब चल रहा था, हमारा सेमिनार जब चल रहा था, तो वन ऑफ माय कलीग हैव सेंड अ क्यूरी. एट द टाइम ऑफ रजिस्ट्रेशन ही गॉट क्यूरीज रिगार्डिंग डॉक्यूमेंट अपलोडेशन, और उसने मुझे स्क्रीनशॉट भी भेजा है. तो उसमें पहला है कि डेविएशन रिपोर्ट विथ रिस्पेक्ट टू मॉडल कॉपी ऑफ एग्रीमेंट, ये पहले वाला है. सेकंड वाला है सेपरेट बैंक अकाउंट डिटेल इंक्लूडिंग नो इनकम्बरेशंस ऑन द बैंक अकाउंट और नो escrow on the same. And third one is deviation report with respect to allotment letter. अभी पहला, ये जो मॉडल कॉपी ऑफ एग्रीमेंट है जो एक्ट में दिया गया है वही रेफर करना है, या उसके बाद में भी अमेंडमेंट हुआ है कुछ उसमें, और
अभी इसमें
वही.
कैसा है ना, ये जो आपको क्वेरी है ना,
हाँ
ये क्वेरी ही नए सिस्टम में इन्होंने ये फील्ड्स
हाँ यही
इंट्रोड्यूस
है,
किया.
अभी 2 दिन पहले अपडेट हुआ है शायद, ऐसे कुछ है.
हाँ, तो ये जो है उन्होंने इतना ही बोला है कि जो भी मॉडल एग्रीमेंट है, अगर आप वो नहीं फॉलो कर रहे तो यहाँ पे डिविएशन रिपोर्ट में आपको येलो में हाईलाइट करना है वट एवर चेंजेस यू हैव डन, एंड दैट नीड्स टू बी अपलोडेड ऑन द दैट वेबसाइट. बट मोर डिटेल्स, एज वो लोग कभी भी फील्ड्स चेंज करते हैं और उसका कोई क्लेरिफिकेशन नहीं देते, तो इन्होंने जो अपना लेटेस्ट ऑर्डर आया था जिसमें लेटर ऑफ अलॉटमेंट आया था फॉर्मेट, उसमें उन्होंने लिखा था द changes which they are there in the allotment letter or agreement for sale, those needs to be highlighted in the with the yellow marker, and then we can upload. और ये जो encumbrance है वो हम लोग जो बैंक अकाउंट में कोई लीन नहीं है या escrow अगर फंडिंग नहीं लिया है तो फिर वो जस्ट डिक्लेरेशन देना रहे. So these are the
वो
new
डॉक्यूमेंट
fields they have
ऑलरेडी
introduced.
एट द टाइम ऑफ रजिस्ट्रेशन लैंड के लिए जो करते हैं वही मॉडिफिकेशन करके बैंक के लिए करवा देना है, इसी है
बैंक
ना.
के लिए.
रिगार्डिंग मॉडल कॉपी ऑफ एग्रीमेंट, अभी ये एडवोकेट से लेना है, वो सीए ने देना है, या फिर प्रमोटर के लेटर पे देना है?
नहीं, मॉडल फॉर्म ऑफ एग्रीमेंट ड्राफ्ट साइंड प्रोफॉर्मा जो हम लोग
नहीं नहीं नहीं,
बिल्डर से
रिपोर्ट,
लेते हैं।
डेविएशन रिपोर्ट, इट्स ए रिपोर्ट।
डेविएशन रिपोर्ट सिर्फ वही एग्रीमेंट में हाईलाइट करके देना, दैट्स इट। वी डोंट हैव टू गिव एनी रिपोर्ट। नहीं, लेटर हेड पे फिलहाल तो कोई गाइडेंस नहीं है उनका ऑफिशियल। सो उन्होंने जो इसमें लिखा था, वो जो ऑर्डर आया, उसमें क्लियरली लिखा है यू जस्ट हैव टू हाईलाइट इट एंड दैट अपलोड ऑन द पोर्टल। सो नो एडवोकेट और सीए रिपोर्ट इज रिक्वायर्ड।
और अभी अलॉटमेंट लेटर जो है उसका ड्राफ्ट नहीं, मेरे ख्याल से सिर्फ उसमें उन्होंने बोला है कि 2% और लेस देन 2% वो कुछ है, वो डिडक्ट कर सकते हैं, उतना ही पॉइंट है। पूरा ड्राफ्ट एग्रीमेंट, ड्राफ्ट अलॉटमेंट लेटर थोड़ी डिपार्टमेंट ने
दिया है,
दिया
पूरा ड्राफ्ट लेटर ऑफ अलॉटमेंट दिया है।
अच्छा, तो मैंने देखा नहीं। सर ग्रुप
कंप्लीट
डाल
रिपोर्ट।
दीजिए आपको,
पूरा लेटर ऑफ अलॉटमेंट दिया।
ग्रुप में डाल दीजिए ना सर, अगर होगा रेडी आपका।
यस यस डेफिनेटली
हाँ हाँ
डाल दो।
ओके।
थैंक यू पुरानी सर, थैंक यू ऑल।
हाँ अच्छा
और
ललित जी,
हाँ सर,
ललित जी, हाँ जहाँ तक आपने
Aditya sir, one question.
यस
Suppose
यस
registration is done, huh? Project completed also, OC is received also, but no RERA compliance is done. What is the savior now?
Registration is done but no RERA compliance is done.
RERA
गुड क्वेश्चन।
registration कर दिया था
बहुत बड़ा
किसी
सक्सेस
CA
है उसके लिए, बहुत
बराबर.
सक्सेस है उसके लिए।
What should be done now?
कौन से सिचुएशन में आप अटक रहे हो वो देखना पड़ेगा सर।
No,
रजिस्ट्रेशन तक था,
मतलब they have appointed me just now. उससे पहला दूसरा कोई था, मतलब he has done only registration और ये लोग ने पूरा बिल्डिंग कंप्लीट भी कर दिया, then they have received OC also, पोजीशन भी दे दिया है. Now what should be done now? Now what is the savior now?
या अनलेस एंड अनटिल अभी ओसी आ गया है, तो अगर किसी ने कंप्लेंट किया और वो चैलेंज कर रहा है कॉस्ट, और अभी मुझे नहीं लगता अगर ओसी आया है तो कोई कंप्लेंट भी नहीं करेगा। सो रेरा ने मोस्टली ऐसे प्रोजेक्ट्स को कंप्लीटेड मान लिया है बिकॉज दे हैव फॉर्म 4 एंड ओसी एंड टिल नाउ देयर इज नो एक्शन बीइंग टेकन। So we are also not aware what action they will take for such projects where compliance is not done and directly OC and Form 4 is applied. क्योंकि होल पर्पस ऑफ द एक्ट जो मैकेनिज्म है वो कभी फॉलो ही नहीं हुआ, तो उसका पेनल्टीज तो कुछ चार्ज नहीं है फिलहाल। तो मैक्सिमम परसेंटेज 5%, 10% वही लिखा है। सो केस टू केस बेसिस पे वो पेनल्टीज चार्ज कर रहे थे फॉर नॉन अपलोडिंग ऑफ द फॉर्म। बट नाउ ओसी है और फॉर्म 4 है, तो रेरा का जो मेन मोटिव है कि प्रोजेक्ट कंप्लीट होना चाहिए वो तो हो गया। अभी वो बैक जाके पेनल्टीज आई डोंट थिंक सो, इवन इफ एनी ऑर्डर कम्स दैट विल बी फ्रॉम फ्यूचर।
That means we have to wait for order only, voluntary not to do
नहीं सर, वो
anything.
सेफ्टी के लिए मैं बोलूंगा आपको, फॉर्म 4
Yes, sir.
और ओसी कंप्लीशन
हाँ,
सर्टिफिकेट और
हाँ.
ये जो कन्वेंस डीड वगैरह है ना, वो अपलोड करके उनको मेल कर
हाँ
मेल
सर,
कर
वो तो
दीजिए।
मैं कर, that I'm
हाँ,
doing.
बाकी फिर
वो कर
फिर
दूंगा
से
तो बस है
बताया
ना,
कि
मेरा
क्या होगा।
मतलब वो है, that is
और
okay
एक
ना.
देखना है,
That is
एक
practical
सबसे
solution.
इम्पोर्टेंट
Absolutely.
बात मुझे ये यहाँ पे मेंशन करनी है कि ओसी कब आया है। उनका जो रेरा का जो रजिस्ट्रेशन है या फिर एक्सटेंडेड रजिस्ट्रेशन है, उसके पहले
हाँ.
ओसी आया है, उसके बाद में आया है। उसके
नहीं सर,
बाद में
अभी
अगर
आया
आया है तो आपको अभी
1 अप्रैल
एक्सटेंशन
22, 1 अप्रैल 22.
नहीं, रेरा का रजिस्ट्रेशन कब तक वैलिड था सर, वो देखना पड़ेगा। और आपका ओसी
रजिस्ट्रेशन
कब
बोल
आया।
रहे हो? रजिस्ट्रेशन का मेरे को याद नहीं है डेट, बट सर उनका ओसी
हाँ,
अभी आया 1 अप्रैल 22 को, और उन्होंने टाइम फ्रेम से पहले खत्म कर दिया, मतलब एवरीथिंग इज डन प्रॉपरली, सबको दे दिया, कुछ भी कर दिया, घर का सामान भी दे दिया, सब कुछ कर दिया सबको। तो कंप्लेंट तो नहीं जाएगा 100%, बाकी तो
कंप्लेंट से नहीं है।
ठीक है, वो अभी कंप्लायंस हर प्रोजेक्ट पे इंडिपेंडेंट डिपेंड है।
थैंक यू सर, थैंक यू सो मच.
Yes.
अच्छा anyway ललित जी, if OC came after expiry of the validity of the registration, then what one should do? क्योंकि उधर
सर उसको
रेरा
पहले
जो है,
तो मेरे हिसाब से, और उनका जो पहले उन्होंने सर्कुलर इश्यू किया है उसमें उन्होंने पॉसिबिलिटीज दी है कि क्या हुआ है बिफोर
हाँ
रेरा डेट। अगर कंप्लीशन है तो नॉर्मल है, अगर रेरा की डेट के बाद अगर कंप्लीशन आ रहा है तो पहले रेरा में आपको अपडेट करना पड़ेगा, फिर एक्सटेंशन देना पड़ेगा, और फिर वो वैलिडेट होगा मेरे हिसाब से।
you are right, I do agree with this. लेकिन सर एक और क्वेश्चन है इससे रिलेटेड, सपोज एक्सपायरी डेट 2019, ओके, एंड नो एक्सटेंशन टेकन, and now project is having suppose one case having OC, पीछे 17 में उसने रजिस्ट्रेशन किया, टिल नाउ जितने भी साल हो गए 4-5 साल, CA सर्टिफिकेट, फॉर्म नंबर 5, एटलीस्ट these two key documents never filed. तो अभी एक्सटेंशन लेने के लिए जब जा रहे हैं तो देन नॉर्मली दे आर आस्किंग सोल्ड अनसोल्ड इन्वेंट्री एंड whatever जो सिक्योरिटी का जो डाउनलोड करके सर्टिफिकेट, एंड देन दिस आर documents, whether since beginning one has to file or last one has to file. Any experience?
सर मैंने ये अभी 2 महीने पहले ही किया है। मैंने अपडेशन के लिए, यानी मेरे को रेफर हुआ है वो केस। तो पहले जो सीए था उसने वो कुछ काम कर दिया था आधा अधूरा और अपलोड कर दिया था और फीस वगैरह पे कर दी थी, लेकिन उनका क्यूरी आया है कि नहीं आपको सब अपलोड करना है। तो मैंने क्या किया कि लास्ट फॉर्म 3, और उन्होंने स्पेसिफिक मेंशन किया था कि 2 साल का आपको ऑडिट अपलोड करना है, फॉर्म 5 लेट्स से 2019 और 20 का या फिर 2021 का। तो उन्होंने फॉर्म 5 यानी ऑडिट दोनों साल का मांगा और फॉर्म 3 जो है वो लेटेस्ट मांगा सर उन्होंने, और बाकी अनसोल्ड, सोल्ड, कमेंसमेंट का डिक्लेरेशन और सेरसाई रिपोर्ट और एसआरओ ये सब उन्होंने लेटेस्ट मंगवाए और एक्सटेंशन दे दिया सर उन्होंने। हर एक फॉर्म 3 अपलोड नहीं करना पड़ा सर मुझे।
So it means those projects which have not followed last 4-5 years compliance, तो उसको लेटेस्ट देने से काम चल सकता है।
हाँ सर, ये 2-3 प्रोजेक्ट मैंने देखा है सर।
तो दैट मीन्स सर जब भी हम लोग को आया तो हम लोग तुरंत अपडेट तुरंत कर दे, ऐसा जो बिलेटेड है
लेटेस्ट
तो
सिचुएशन में अपडेट कर देता हूँ सर, लेटेस्ट सिचुएशन अपलोड कर देता हूँ सर
कर देने का ना, तो दैट विल बी बेटर नो देन। ओके।
अगर
अच्छा,
क्लाइंट बहुत ही अच्छा रिस्पांस दे रहा है और बोल रहा है कि पिछला भी अगर क्लियर कर दो, तो वो सिचुएशनल एक क्लाइंट आया था मेरे पास, तो मैंने पूरे फॉर्म 3, 1, 2, 3 और 5 भी अपलोड किए थे सर पूरे।
तो पूरे आप कैसे करते हो? जैसे 4 साल का है तो वेदर यू आर डूइंग ईयरली और क्वार्टरली और हाउ?
मैं पूरा अकाउंटिंग डेटा पे डिपेंड किया है सर उस प्रोजेक्ट में, कि जितना
हाँ,
खर्चा
तो
दिख रहा है उसके हिसाब से मैंने अभी कर दिया था, और जो लास्ट क्वार्टर था करंट उसको मैंने उसको सिंक्रोनाइज किया था।
सर लास्ट
मेरा
मतलब
तो
अभी सपोज, सॉरी
हाँ, कंटिन्यू मिनेश भाई, आप पूछो।
हाँ मैं क्या बोल रहा था सर, सपोज आप बोल रहे हो कि मैंने 1 साल का पूरा कर दिया था, दैट मीन्स यू आर पुटिंग 4 क्वार्टर वाइज और अप टिल दिस डेट ओनली, करंट डेट ओनली, मतलब एक ही करते हो क्या, मतलब 4, मतलब कैसा करते हो,
नहीं,
मतलब 4?
वो पर्टिकुलर प्रोजेक्ट में मैंने 4 किए थे सर, और बाकी जो प्रोजेक्ट है 2-3 उसमें मैंने लेटेस्ट वाला करवा दिया था सर।
नहीं मतलब एक साथ 4 भी कर सकते हैं क्या, ऐसा पूछ रहा हूँ।
हाँ, अपलोड कर सकते हैं ना सर,
डेट वाइज डाल के।
डेट वाइज अपलोड कर दीजिए आप एक एक करके एडिशन
ओके
करके।
सर।
और
ओके सर।
स्पेसिफिकली मैं बोलता हूँ कि अभी 7th ऑफ नेक्स्ट क्वार्टर, 7th डेट ऑफ नेक्स्ट क्वार्टर एंड अपने को अपडेट करना है क्वार्टरली। बहुत सारे
7
बिल्डर
जुलाई
नहीं कर रहे हैं, बराबर। तो उसमें क्या होता है कि पहले 3 क्वार्टर नहीं करता हूँ मैं, सिर्फ 4th क्वार्टर के लिए फॉर्म 3 इशू करता हूँ, और वही उसी फॉर्म 3 के डिपेंड फॉर्म 5 अपलोड ये करता हूँ सर, रेडी करवाता हूँ मैं।
तो ये जो आप फॉर्म करते हो तो उसमें एज ऑन डेट बनाते हो ना सीए सर्टिफिकेट, उसमें
हाँ बिल्कुल
क्वार्टर वर्ड
सर,
लिखना जरूरी नहीं है
एज
ना?
ऑन डेट, एज ऑन डेट।
ओके। अभी फॉर्म नंबर 5 कंसीडर वो हम और आप में कोई इशू करने वाले हैं, राइट? और उसमें कंडीशन है कि वेदर द कंप्लायंस ऑफ रेरा हैज बीन डन, इट मींस फॉर्म
नोट
1
देना
to
है
3।
आपने, नोट देना है ना कि फॉर्म 3 अपलोड नहीं हुए इस क्वार्टर के,
ओके,
या फिर सिंपली आप अगर नहीं मेंशन करना चाहते हो तो क्वार्टरली अपडेट्स और वेयर नॉट मे डन डेट,
नॉट मेड प्रॉपर्ली, ऐसा
हाँ
क्वार्टरली
ऐसे कुछ।
अपडेट नॉट डन प्रॉपर्ली, ऐसा करके दे दे। ओके।
तो हम तो बच जाएंगे, लेकिन डेवलपर तो फंसने के पूरे चांस है उसमें, नहीं?
सर वो ऐसे भी अपलोड नहीं किए तो फंसेगा ही नहीं सर, तो उससे
नहीं,
अच्छा है
दोनों
कि
में फर्क है, दोनों में फर्क है। जो अपलोड नहीं किया वो 4500 तो डिफरेंट स्टॉल प्रोजेक्ट्स ऑलरेडी है अपने पास, और मे
नहीं
बी
सर,
3-4,000
ये
और भी है।
बात आपको क्लाइंट को कॉन्फिडेंस में लेने के बाद ही करना है। अगर क्लाइंट बोल रहा है कि सर मुझे चारों क्वार्टर अपडेट करके दीजिए, तो वेल एंड गुड, अपने को कोई दिक्कत ही नहीं है। अगर क्लाइंट चाहता ही नहीं है, बिल्डर चाहता ही नहीं है कि नहीं सर मैं इतने 4 क्वार्टर की फीस नहीं दूंगा, एक ही क्वार्टर की फीस दूंगा, तो आपको एक ही क्वार्टर करना है सर।
उसको क्वार्टर वर्ड तो नहीं बोल सकते, बिकॉज व्हेन अभी लास्ट का करते, समझो 4 साल से उसने सर्टिफिकेट दिया नहीं, तो टिल डेट जो भी कॉस्ट इनकर्ड हुआ, ट्रायल बैलेंस तो उधर से लोगे आप, उसके टैली से। तो फिगर है, अभी मान लो 50 करोड़ का प्रोजेक्ट है, आप लास्ट में उसको अपडेट कर रहे हो तो 50 करोड़ को सर्टिफाई कर रहे हो आप।
हाँ
प्रीवियस आप बच सकते हो नोट डाल के कि आई हैव डन एज ऑन डेट, लेकिन you cannot escape your from your responsibility that this expenditure has been incurred for the particular heads of the project, क्योंकि उसमें अलग से आपको कुछ नहीं है, जो फॉर्मेट है उसी को फिलअप करके साइन करना है। आर यू गेटिंग माय पॉइंट? एज ए सीए
आप बोले हो ना 50 करोड़ में से समझो 30 करोड़ अभी खर्चा हो गया। आज अगर मैं सर्टिफाइड कर रहा हूँ तो मैं 30 करोड़ का ही दूंगा ना।
30 करोड़ के लिए हम अकाउंटेबल हैं आज के डेट में।
बस
करेक्ट, वेरी गुड।
तो हम लोग को प्रमोटर को बोलना पड़ेगा, तो आप 4 लाख के दे दीजिए, हम लोग कर देते हैं, तो 5 में कुछ आएगा नहीं। और हमारा फीस
ललित का प्रैक्टिकल सॉल्यूशन है सर। यूडीएन के कारण अभी बैकडेटेड तो कुछ नहीं हो सकता।
नहीं सर, नहीं सर, यूडीएन की वजह से ही हमें एज ऑन डेट ही सर्टिफाइड करना है। हाँ, आर्किटेक्ट इंजीनियर का बैकडेटेड आपको मिलता है सर, डेफिनेटली मिलता है, लेकिन सीए सर्टिफिकेट फॉर्म 3 आपको विद इन 15 डेज का ही करना है, या फिर 18 डेज का। लेकिन क्यों 19 डेज भी देखो, करंट डेट का भी इशू कीजिए ना सर यूडीएन।
करेक्ट। अच्छा, व्हाट इफ समझो वी सीए आर concerned with the compliance, right? एडवोकेट और सॉरी आर्किटेक्ट और इंजीनियर को बहुत ज्यादा पड़ी नहीं है, वो मांगेंगे तो वो दे देते हैं। एट टाइम्स दे से कि आपका कितना खर्चा हो रहा है, हम उसके बेस पर इंजीनियरिंग का परसेंटेज वर्कआउट करके आपको दे देंगे, और आर्किटेक्ट भी ऐसा ही बोलते हैं मोस्टली। और एट टाइम्स दे डोंट गिव, लेकिन हम सीए सर्टिफिकेट दे रहे होते हैं, तो उसमें नोट में हमें डालना चाहिए क्या फॉर्म 1 and 2 हैज नॉट बीन गिवन टू अस फॉर आवर सर्टिफिकेशन?
नहीं ना सर, फॉर्म 1-2 बेस पे ही आपको 3 बनाना है फॉर दैट पर्टिकुलर।
फॉर्म 1 पे तो कुछ लेन देन नहीं है हमारा, इंजीनियर सर्टिफिकेट
आता है ना, परसेंटेज ऑफ कंप्लीशन आता है ना, और इंजीनियर आपको कॉस्ट इनकर देता है और बैलेंस कॉस्ट कितना
मिसमैच होगा तो क्या करने का? अभी सपोज उसने 15 लाख
मिसमैच होना ही चाहिए सर, फॉर्म 1, 2, 3 में मिसमैच होना ही चाहिए।
हाँ, क्योंकि अभी मुझे आया है वो 15 करोड़ का है और हम ये लोग का खर्चा 21 करोड़ हुआ है।
हाँ, तो वो खर्चा डिफरेंस आना ही चाहिए सर, तो ही वो
whichever is low वही जाएगा उसमें। इफ यू सी द टेबल 2B, you will see that whichever is low कंस्ट्रक्शन कॉस्ट में, that portion will be covered as a incurred। लेकिन आपका ये बहुत वैलिड पॉइंट है कि इंजीनियर पोस्ट इनकर्ड का सर्टिफिकेट में मेंशन है, तो विदाउट हैविंग द इंजीनियर सर्टिफिकेट हम लोग उसको कैसा दे सकते हैं? बिल्कुल सही। यदि इंजीनियर ने सर्टिफिकेट नहीं दिया, बिल्डर ने दिया और हमने मेहनत कर ली, तो क्या ऑब्जर्वेशन जी में हम ये डाल सकते हैं, इंजीनियर सर्टिफिकेट हैज नॉट बीन प्रोवाइडेड एंड दैट हैज बीन सर्टिफाइड बाय द मैनेजमेंट एंड बेस्ड ऑन दैट वी हैव बीन सर्टिफाइड द सीए सर्टिफिकेट? क्योंकि हम तो
डिस्क्लोजर सेफ्टी के लिए ओके, लेकिन लॉ का कहना ही है कि आप सीए ने क्या करना है कि जो इंजीनियर सर्टिफिकेशन देता है कॉस्ट का, उसके रिगार्डिंग जो बिल्स है और जो बुक्स ऑफ अकाउंट में एंट्रीज है वही हम वेरीफाई करना है सर, कॉस्ट नहीं दे सकते सर हम, हमें सिर्फ वेरीफाई करना है बुक्स ऑफ अकाउंट और बिल्स एज पर माय नॉलेज। तो आपको लेना ही है।
तो जो सर्टिफिकेट के 2 कॉलम जहाँ पे कि एज सर्टिफाइड बाय इंजीनियर वर्ड लिखा है ना, वो डिस्क्लेमर में हम डालने का हक है एज ए चार्टर्ड।
वो बिल्कुल सर,
तो
वो तो नोट्स में तो सेफ्टी के लिए कर सकते हैं हम, और ये भी कर सकते हैं कि क्वार्टरली अपडेट करना था, इंजीनियर नहीं दे रहा है, लेकिन हमारे पास कॉस्ट है और बिल्डर कंप्लायंस करने की कोशिश कर रहा है, तो बिल्डर सेव कर रहे हैं हम लोग, तो उनको एक्सेप्ट करना पड़ेगा सर।
करना वो तो रेरा नेवर आस्क कि आप क्या सबमिट कर दो, ओनली दे हैव गिवन द विंडो टू अपलोड।
हाँ, बस
जिस दिन वो जगेंगे, उनको लगेगा कि हमें कोई एक्शन लेना है, तो हम प्रोफेशनल के लिए कुछ नया वेन्यू खुलेगा। मैं तो ये मानता हूँ।
अभी ये भी है सर कि सुमोटो वो एक्शन ले पाएंगे या कब ले, यानी
कब लेंगे, क्या लेंगे,
इस पे डिस्कशन होना चाहिए सर अभी। जैसे कि सुमोटो का टॉपिक है।
तो यस ये गुड क्वेश्चन। तो हम लोग जो है ना रेरा का अभी बीच में थोड़ा केसी कॉलेज में एक सेमिनार हुआ था, जहाँ की जो चेयरपर्सन भी आए थे, अजय कुमार, अजय मेहता साहब, एंड देन जो विजय सतवीर सिंह भी थे, एंड MCHI के प्रेसिडेंट भी थे, एंड फ्यू अदर डिग्निटरीज। तो वहाँ पर ऐसे नॉन कंप्लायंस बहुत ज्यादा है। 4500 प्लस तो स्टॉल प्रोजेक्ट्स है, 3-4,000 आर इन द पाइपलाइन दैट कैन आल्सो कम अंडर द स्टॉल इन द कमिंग टाइम। तो वो लोग दे आर आल्सो स्ट्रगलिंग विद टू हाउ टू कम आउट विद दिस। ये कैंसर नए प्रोजेक्ट्स को नहीं लगे, पुराने को कैसा हम हैंडल करें, नए को स्ट्रीमलाइन कैसा करें, दे आर आल्सो वर्किंग ऑन इट। मे बी जो नया रजिस्ट्रेशन प्रोसेस दे हैव बीन स्टार्टिंग इज मे बी द पार्ट ऑफ इट, समथिंग जो नए प्रोसेस में है। तो हम लोग, आदित्य जी इधर हो आप? आदित्य जी?
यस सर, बोलिए।
हाँ, अच्छा, अभी जो न्यू रजिस्ट्रेशन दे आर अपडेटिंग बाय 30th of June, मीन्स टुमारो, राइट? तो मुझे लगता है कि दिस इज वेरी क्रिटिकल सब्जेक्ट विच वी शुड बी अवेयर, and we all members who are responsible for new clients or existing clients to register any new project. तो इसके लिए हमें एक टॉपिक बहुत शॉर्ट पीरियड के लिए रख सकते हैं क्या?
टॉपिक मतलब बाद में ना, अभी आने के बाद।
जैसे अभी 30 तारीख तो कल है, राइट? और जैसे कल वो लोग तो अपलोड कर देंगे क्या नया रिक्वायरमेंट्स है, हमें उसको स्टडी करके मेंबर्स के बीच में ब्रेनस्टॉर्मिंग हो जाए। कैन वी कीप विद इन अ वीक्स टाइम any say our monthly program is the minimum, right? We can have sometime more than one. In the interest of members, can we keep some time? आप अपना कैलेंडर चेक करो ना, if we can declare now, तो बेटर होगा कि वो मीटिंग महीने के लिए काउंट कर लेंगे हम लोग, और हो सकेगा तो दूसरा भी हो सकेगा मीटिंग।
ठीक है, तो वो WIRC से हम लोग बात करके बता देंगे ना। वी कैन हैव अ वर्ड विद WIRC कि हम लोग कनेक्ट कर सकते हैं कि नहीं। ऐसा
नहीं कर सकते हैं, मैंने बात किया हुआ
कर
है।
सकते हैं, लेकिन कौन से डेट पे वगैरह वो अवेलेबिलिटी
वो
देख
हम
के
लोग वेरीफाई करेंगे उनसे। मैं खाली इतना ही पूछ रहा हूँ कि आपका कैलेंडर चेक करो, मैं भी देखता हूँ, सो दैट एटलीस्ट some information here we can put for members कि आप भी अपना कैलेंडर अवेलेबल रखना। कंफर्मेशन we will put after verifying from WRC।
ओके।
हाँ, तो जुलाई का विद इन 7 days इफ पॉसिबल, तो आप चेक करो कौन सा डेट आपको लगता है कि अच्छा रहेगा।
बाकी लोगों के लिए भी कौन डिसाइड कर सकते हैं?
नहीं, बाकी अपने मेंबर्स के लिए तो उनके बेनिफिट के लिए हम लोग करना चाह रहे हैं, वो आप छोड़ो। आपका अवेलेबिलिटी होना एज ए कन्वेनर बहुत ही इम्पोर्टेंट है।
7 तारीख को कर सकते हैं।
ओके, तो मेंबर्स प्लीज कीप नोट that we may come with the option for the evening session regarding registration of projects. Okay, and who will take lead? समझो हम दो तो है, हम चाहते हैं कि आप में से भी कोई एक्टिव रोल प्ले करो। Your involvement will increase others' knowledge, your knowledge. So who will take lead? ललित पवार जी, आप लेना चाहोगे सर? You are doing lots of registrations.
नहीं, ऐसा कुछ नहीं सर। ठीक है सर, अगर कोई बंदा नहीं आता है सामने तो मैं
नहीं, ऐसा नहीं, बंदे तो सारे आ जाएंगे, आप चिंता मत करो। आप लीड लेते हो तो वी कैन कीप इन माइंड, हमें WRC में भी नाम वगैरह देना पड़ता है। इफ दे विल एग्री देन एवरीथिंग विल बी रेडी विद अस।
ग्रुप पे डिस्कस करते हैं ना सर, कोई इशू
नहीं, ग्रुप में नहीं, हम तो आपसे आपका कंसेंट ले रहे हैं।
आई ऑल्सो अग्री विद ललित। ग्रुप में डालिए सर, आदित्य को, ललित को उतना प्रेशर में मत डालिए।
नहीं, प्रेशर नहीं है सर, इट इज वो करेंगे हम
गिव
लोग,
देम
ग्रुप
सम
में
टाइम
डालेंगे।
सर, 12 घंटा
ठीक
ग्रुप
है,
में डाल लीजिए ना, फिर
चलो
आप डेट से ही रखिए, डेट यही रखिए। कोई भी स्पीकर अगर
डेट और
okay
टॉपिक ये कर दीजिए, फिर अपन डिस्कस करते हैं ना।
चलो ठीक है, देन वी कैन पुट इन द ग्रुप कि ये हम चॉइस कर रहे हैं। इन द मीन टाइम वी कैन टेक अप्रूवल फ्रॉम WRC and then we can put. By tomorrow I will try to get the approval. I think we have completed, we have exceeded the timelines, and this is the interest our members have taken in the topic. 11 जो है ये डायमंड है हमारे इस रेरा की प्रैक्टिस के लिए. I can say that because all are participating, and there are people who are silent but they are actively engaged in listening all those answers. So I really appreciate all the members and those who have keenly participated, contributed their experience, and I also acknowledge the kind of knowledge, detailed, depth study our today's speaker Atul Rupani Sahab has shared with us. I was surprised to listen so many things. सुओ मोटो तो मेरे को एक छोटा सा वर्ड दिखता था, और जहाँ पे कोई कंप्लेन नहीं कर रहा हो वहां पे न्यूज़पेपर का कटिंग पढ़ के कोई इंफॉर्मेशन पास ऑन किया रेरा अथॉरिटी को, तो वो एक्शन कुछ ले सकता है, नोटिस भेज सकता है, इतना तक ही मेरा नॉलेज था उसके ऊपर. लेकिन जो कुछ भी पुरानी साहब ने आज शेयर किया, इट इज माइंड ब्लोइंग. सो डेप्थ ऑफ द सब्जेक्ट दैट सुओ मोटो अभी अंदर तक आ गया कि सुओ मोटो टॉपिक आएगा तो नाउ वी कैन रिप्रेजेंट वेरी पावरफुली. और पीपीटी भी आपने शेयर किया है, विच विल बी शेयर टू ऑल द मेंबर्स फॉर देयर इंटरेस्ट एंड बेनिफिट. एंड विद दिस just a minute. Rupani Sahab also shared about the provisions of Code of Civil Procedure 1908 and Evidence Act. These are not completely found on the tribunals. Sometime when we can appear before tribunal, we can see lots of advocates are coming strictly mentioning various provisions, and then at least I can say for myself, then वहाँ पे I keep यार ये तो I don't know anything about whatever they are telling, and they are supporting with some judgments also, so I am helpless. Means my knowledge is related to RERA and provisions and some of the judgments which we in day-to-day life handling. Then today what takeaway is, we can fight with and present ourselves that see whatever my dear opponent advocate, learned advocate is sharing is at all not applicable to the tribunal. It is the choice and discretionary power of the tribunal to the extent which is technically, very technical subject, Evidence Act and the Code of Civil Procedure to be accepted only to limited extent, because we are not the High Court advocates or Supreme Court advocates. Secondly, the suo moto power is limited only to the authority. Why? Law has provided with certain intents, and that power can only be used by the authority, cannot be used by the tribunal, suo moto, or by taking those powers as granted, because they are the judiciary. Their power is only limited to see whether the order is justice in the natural justice, or it is, or they want to give some direction or set aside or some different judicial order on their orders. It is limited up to that only, which is this is what I can take from this. With this, I can really propose a very hearty vote of thanks on behalf of WIRC RERA study group members. And please give a round of applause to our CA Atul Purani sir.
Thank you so much, sir.
Thank you, sir. अच्छा, नेक्स्ट स्पीकर आप में से कोई बनना चाहेंगे? प्लीज हियर गिव सम क्लू. We will keep in mind because it's a platform where you can grow yourself, and our intention is during the whole year we will have 12 months, and 12 months में कम से कम 24 तो हमारे जवान निकलने वाले. बोलते हैं ना कि बॉर्डर पे जो होते हैं वो पहलवान होते हैं, किसी को भी फेस कर सकते हैं. तो इस रेरा स्टडी ग्रुप के जो चार्टर्ड अकाउंटेंट मेंबर्स हैं, they should be distinct than the other chartered accountants. तो आप में से थोड़ी आप हिम्मत करो और हम आपके साथ हैं. आप कभी भी हारोगे नहीं. It is our promise. So who will dare to come with whatever preparations you can make. ये जरूरी नहीं है कि 2 घंटा आपको लगता है कि ज्यादा है, तो you can come with half an hour or you can come with 1 hour. You tell कि मैं particular चीज पे preparation करके आऊंगा. At least you will be thorough in the subject. Presentation skill आपकी automatic develop होती है, and you will be giving advantage to the public at large, because RERA is not limited for chartered accountant or advocates. It's a subject which benefits the public at large. रोटी और कपड़ा और मकान का मामला है सर. मकान सबको चाहिए, आप उनको सोर्स बन सकते हो शक्ति देने का. तो आप में से कोई रिक्वेस्ट करूं, यदि हमें सामने दिख रहे हैं मिनेश भाई, करेंगे आप? और
सर अभी जुलाई के बाद रखेंगे सर. जुलाई के बाद
चलो
मैं करूंगा.
अगस्त में मैं आपका नाम नोट करता हूँ, बराबर
पक्का
है?
100%.
और आप सोच के
हाँ.
क्या करना चाहेंगे वो हम लोगों को पर्सनल पे शेयर कर दीजिए.
हाँ.
और संजय
Yes, sir.
यादव साहब,
Once this return filing season will end, no?
मेरे
Not
को
only
नहीं पता, मैं रिटर्न नहीं फाइल करता हूँ. मैं आपसे अगस्त महीने की बात, आपने बोला मैं अगस्त का लेता हूँ. वट एवर
नहीं
डेट
सर,
वर्क्स
मतलब
फॉर यू.
रिटर्न फाइलिंग का
Manish,
सीजन खत्म हो जाएगा तो I'll voluntarily come and join, sir. Don't
yeah,
worry.
yeah, Manish, in the
एक से ज्यादा
past,
लेंगे.
हाँ,
Manish,
चलेगा
in the
सर, बहुत
past
अच्छा.
क्या था, starting में आप you can take updates and notification also. In the past we used to have that kind of a meeting कि 2 मीटिंग के बीच में जो notification आए, circulars आए, you can start with that also, Manish. It will be
ऑलराइट, ये
really
भी
a
कर सकते हैं
contribution.
जो. करेक्ट, वेरी गुड. एक तो वो उन्होंने बताया. सेकेंडली, यू विल कम विथ व्हाट एवर न्यू जजमेंट्स यू कुड हैव सीन इज डिफरेंट देन नॉर्मल जजमेंट्स. तो 1-2 जजमेंट लेंगे तो आपका 1 आध घंटा यूज हो जाएगा. एंड
Yes, sir.
संजय यादव जी, आप क्या लेना चाहेंगे सर?
हाँ, अगस्त में करेंगे क्योंकि अभी जुलाई में काफी सेटिंग ये है इनकम टैक्स के
अच्छा,
मैटर्स है.
ठीक है.
तो इन
दैट
अगस्त डेफिनेटली.
संजय,
थैंक
तो
यू सर,
आप
थैंक यू.
हाफ कर लो, आप और मिनीश हाफ भी कर सकते हो अगस्त में.
हाँ, जो
हाँ,
करना
मैं
चाहें.
संजय जी को कॉल करके हम लोग दोनों एक सेशन शेयर करके अगस्त में
Yeah,
हम
we
लोग.
can start that also. You see, anything is beginning, sir. Thank you.
Yes,
Thank you.
yes.
Yeah, sure.
Superb. Thank you for accepting our request. And आपको एक नया असाइनमेंट देता हूँ. ये मैं हक लेता हूँ, not as a group member but as a deputy convener, to empower you. You take a stand for other 1 or 2 other members. जैसा आप लेने वाले हो, दूसरे से बात करो और उनको हमारा और आदित्य का या अदर मेंबर्स का, हम दो तो 100% कोई भी सपोर्ट करेंगे उनको आगे बढ़ने के लिए. कुछ प्रिपरेशन में कहीं रुकावट है वो भी हम सपोर्ट करेंगे. और लेट टू न्यू पीपल, यू पीपल शुड डिमांड फ्रॉम देम कि नेक्स्ट सितंबर में आपको देना है. दिस इज द असाइनमेंट फॉर यू. क्यों अतुल साहब? राइट सर. ओके, थैंक यू सो मच.
Yeah.
We
Thank you.
conclude this meeting.
Thank you everyone.
Yes.
Thank you. Thank you.
Thank you, sir. Thank you,
Yeah.
everyone.
Thank you Aditya ji. Thank you.
Yes, organizers, please complete this meeting.